May I please, my lord? My lord, I'd like to mention item number 6. Oh, item number 5, my lord. My lord, conducting counsel, Ms. T. Ginny is out of station on medical ground, my lord. It may be adjourned and taken up after 2 weeks.
Other side you have informed.
Yes, I have informed the other side.
Heard Miss
M. Karbak,
M. Kapak,
Karbak,
learned counsel for the petitioner who prays for an adjournment on the ground of ailment of the conducting counsel, Mr. T. Genie. She has also submitted that the other side, she has taken the consent of the other side. Considering the submissions made by learned counsel,
my lord, there is an interim order. It may be
let
continued.
this matter be listed after
2 weeks.
2 weeks. The interim order shall continue till next day.
May Your Lordship? Your Lordship, I beg to mention item number 13, Your Lordship. This matter may be listed next week, Your Lordship.
1-3,
Yes, Your Lordship.
what is your prayer?
Matter to be listed in the next week, Your Lordship.
Reason?
This is actually here, so I'm appearing, Your Lordship. I'm not well today.
Okay. Heard Miss
P. Pangu, Your Lordship. Government advocate, Your Lordship.
Heard Miss P.
Pangu.
P. Pangu, learned government advocate, appearing for the respondent side. You have informed the petitioner.
Yes, Your Lordship. I've taken consent, Your Lordship.
Who prays for an adjournment as she is not prepared with the brief.
I have prepared as not well, Your Lordship.
Okay. Heard prays for an adjournment on the ground of personal difficulties. The learned Mr. T. Som, learned counsel for the petitioner, does not opposes the prayer. Hence, the prayer is allowed. Let this matter be listed after
Next week, Your Lordship.
a week.
Yes, Your Lordship.
My lord, I beg to mention item number 9. On behalf of N. Ratan, I brought a petitioner here. My lord, this matter may be taken up to 3 weeks, my lord. I've taken the consent from other parties.
Heard Mr.
T. Tabgu,
T.
Tabgu.
Learned counsel for the petitioner, who prays for an adjournment for 3 weeks, and he has also taken consent of the learned counsel for the respondent side. Considering the submissions made by the learned counsel, the prayer is allowed. Let this matter be listed after 3 weeks.
My lord, interim order may be
The
continued.
interim order shall continue till next day.
Much obliged.
May I, Lordship. Lordship, I beg to mention item number 14. 1. On behalf of Mr. D. Pangu, my lord.
Yes.
My lord, I have taken consent from opposite party, my lord. So matter may be listed after 2 weeks, my lord.
What is the difficulty? Why you are?
My senior has instructed me to adjourn the matter. My lord, my senior is there in the court 1, my lord. And he has a hearing in the court number 1, my lord.
Okay, heard Mr.
K. Adam.
K. Alo, learned counsel for the appellant, who prays for an adjournment on the ground of personal difficulty of the conducting counsel, Mr. D. Pangi. He also submits that he has obtained the consent of learned counsel for the respondent side, who does not opposes the said prayer. The prayer is allowed. Let this matter be listed after 3 weeks.
Yes, my lord.
What was your prayer? 2 or 3?
3 years. 3.
3 weeks. Okay.
Deeply obliged, my lord.
Lordship. Lordship, I beg to mention item number 1 on behalf of T. Tagum. Lordship, the leading counsel, due to his personal program, he could not appear.
Heard
Consent has been taken.
Miss
R.C. Lawangcha.
R.C.
Lawangcha.
Lovangcha,
Lordship, yes. Yes, Lordship.
learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of leading counsel, Mr. T. Tagum. She also submits that she has obtained the consent of the
Maybe,
learned
Lordship, matter may be taken up tomorrow.
counsel for the other side and prays for listing this matter tomorrow. The prayer is allowed. Let this matter be listed on 7th of September 2023.
Lordship, I on behalf of counsel of the petitioner, item number 15 is adjournment for today.
Item number
15. Adjournment for today.
yes. Yes, what is your prayer?
The council is unable present to hear due to some rituals in his
Who is the council? Jayat
Tigame,
heard Miss what's
B
her-
Tasuso,
B
Tasuso,
Tasu
so,
Tasun
so,
spelling.
Tasuso.
You take the name later on. Learned counsel for the petitioner whose prays for an adjournment on the ground of personal difficulty of the conducting counsel, Mr. T. Game. She has also submitted that she has obtained the consent for adjournment from the learned counsel for the respondent side. The prayer is allowed. Let this matter be listed after
20 September,
2 weeks.
20 September.
You want a fixed date.
Yes.
Let this matter be fixed on 20th of September.
Hi, my lord. I'd like to mention item number 3, my lord, on behalf of C. Modi, my lord. He, due to some personal difficulties, my lord, he is not able to come to the 3,
Heard Miss
Tirimi,
T. Remy,
Tirimi.
learned counsel for the petitioner who submits that who prays for an adjournment on the ground of personal difficulty of conducting counsel, Mr. C. Modi. Learned additional PP does not oppose the said prayer. The state is. Yes. The prayer is therefore allowed. Let this matter be listed
After a week's notice.
after a week. Let this matter be listed after a week.
God bless, my lord.
May I, your lordship? So, lordship, I'd like to mention item number 2. As my leading counsel is out of station. This letter may be listed after 1 week.
You
I
are
have taken
for
petitioner, sole petitioner,
heard Mr.
J. Typodia,
J.
Typodia,
Typodia,
yes.
learned counsel for the petitioner who prays for an adjournment on the ground that the leading counsel in this case is out of station. You have informed the other side.
Yes.
Learned counsel also submits that he has informed the learned counsel for the other respondent side. Hence, the prayer is allowed. Let this matter be listed
After 1 week.
after 1 week.
My lord, may I mention item number 8, my lord? My lord, my senior N. Duncan is unable to attend today before this court. My lord, because my lord, Chief Justice of Guwahati High Court, my lord, has appointed her in a POSCO case as a legal aid counsel, and today she will be busy in that case. So, my lord, I have taken consent of the other side, my lord. And this matter may be,
Mr.
my lord,
What is your name?
Odugong. Maybe fixed tomorrow, my lord.
What is your name?
Odugong, my lord. Odugong.
Mr. O. Dugong, learned counsel for the petitioner, prays for an adjournment for a day on the ground that the leading counsel for the petitioner, Miss N. Dangeng, is not available today. Learned additional PP does not opposes the said prayer. Let this matter be listed
Tomorrow, my lord.
Tomorrow.
on 7th of September
Compliance. Compliance.
Compliance.
Let me please you. And I beg to mention item number 4, 6, 7, and 12. The leading counsel, Mr. Mukherjee, could not be present here because of some health issues on her.
Four. Item number 4.
Item number 4, 6, 7,
7
and 12.
and 12. In all
Senior
these
counsel.
cases, heard Miss
T.Y. Bhutia, Chiring Yangzong Bhutia.
Heard Miss T.Y. Bhutia, learned counsel for the petitioner, learned counsel for the appellant, who prays for an adjournment on the ground of personal difficulty of the leading counsel, Mr. Muk Partin. You have informed the other side.
I am in item 4, my lord.
Item number 4.
She also submits that she has informed the learned counsel for the respondent side, who does not have any objection to this said prayer.
I am for 6, 7, and 13, 12. 12, yes.
Regarding respondents counsel, you from the cause list you mentioned. Considering the submissions made by learned counsel, the prayer is allowed. Let these matters be listed after
4 weeks,
2 weeks,
2 weeks.
because different matters are there. RSAs
RSA, if they are not
after 4 weeks, okay.
after 4 weeks,
Okay.
specific date, 3rd, that is Tuesday, 3rd October.
Item number 4.
4, item 4. my lord.
Item number 4 may be fixed on 3rd October, others after 4 weeks.
Highly obliged.
Obliged.
Yes.
8, pleases your lordship.
My lord. This. My lord, this criminal petition is filed assailing the order of framing charges against my client under section 193 para 2 stroke section 465 of the IPC. My lord, I have challenged in this criminal petition the initial FIR, the charge sheet, as well as the order framing charges, my lord. My lord, my first limb of argument would be the entire proceeding is hit by the provision of 195 CRPC. My second limb of argument would be that this proceeding has emanated from a MEL meeting, that is the village authority under the Assam Frontier Administration of Justice Regulation 1945. This entire proceeding has emanated from an order passed by a MEL meeting, that is a Kebang, my lord. That's a village authority, the local village authority.
What is the difference between male and nile? You have heard the word nile. Yesterday I came across the word.
I know MEL and Kabang, I know, my lord.
Male belongs to the Nishi community.
There is a word nile. Nile or mile. Yesterday, Mr. Muk Partin.
It was male, your lordship, male.
MEL,
No,
it would be
no. It is,
We are aware of male and Kabang, your lordship. Male and Kabang.
even I am also aware of MEL.
and nile.
Yes, I'm not aware.
Is there any word nile?
Some community of especially this part of the district, they use the word Nile,
Nile.
Vale, and the Teva, all are same only. Same language. But for other community, they are using.
So male and nile are same thing.
Might say.
But you have, additional people have not heard the word nile.
I've not heard the Nile, only male, your lordship, we have. Not the-
Okay. Okay.
and Kebang, my lord.
Okay.
So, my lord, this is emanated from a decision.
How matters are resolved in Kebang? How Kebang are the customary
The Gaumburas of
in the instant case,
that
Kebang is relevant.
in the instant case, the Kebang was held in Papumpare district, whereas both the informant, the complainant in the Kebang and the other side, opposite side, that's my client, both are original inhabitant of Pasigat. So the Kebang could not have been held at Itanagar. My lord, I'll come to that, my lord. Before that, my lord, this entire case, with respect to my second limb of argument, the entire case emanates from a decision passed in a Kebang at Itanagar at this Papumpare district, and the validity of that Kebang is under challenge. That Kebang decision is under challenge before this High Court in a writ petition where there is a stay order operating. So, my lord, if the Kebang decision goes in that writ petition, the entire edifice of this case falls. I will demonstrate during the course of my argument that if the foundation of a criminal case is gone, then the entire structure will fall.
Okay. Now what is
So these are my two limbs of argument. One is hit by 195 and the other is that the foundation of this case, which is a Kebang decision, is under challenge and which is in straight violation of a notification passed in consultation with this High Court by the government in 2014. Because since 2014, all civil and criminal disputes, it was directed that no deputy commissioner or assistant commissioner will have the power to entertain any civil or criminal disputes, and those cases pending before them will have to be forthwith handed over to the concerned civil judge and the chief judicial magistrate in 2014. And this notification has also got the sanction of an order passed by this court. I'll take your lordship to all those documents, my lord, which I have annexed, my lord. So, my lord, this order of cognizance lacks jurisdiction because it is hit by 195. That's how I start my argument, my lord. Now, my lord, the basic facts, how this case emanated, my lord, the basic facts. My lord, will kindly come to page number 34.
What is 465?
465 is forgery.
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 And 193?
193 para 2 is tendering false evidence.
False evidence.
False evidence.
Okay.
Now, my lord, the entire thing, my lord, it started from page number 34. My lord is
Money loan receipt.
yes. This started from here. Here, my client has taken a loan of rupees 5 lakhs from the informant, 5 lakhs from the informant, with a condition that he will repay it within 3 months at the rate of 8% interest per annum. Per month, not per annum, 8% per annum interest for 3 months.
Per month interest.
Per month 8%. So it would come around 6,24,000.
Okay.
So, my lord, after taking this money, my lord, we are not disputing receipt of money. We have received this money in terms of this loan agreement. My lord, after taking this loan, my lord, because of some dispute, my lord, because, my lord, I am aware that I am arguing under a jurisdiction of 482. Therefore, there is very limited scope to argue on evidence, my lord. So therefore, my lord, I will just take your lordship to those piece of documents which are admitted by both the sides and where there is no dispute. And primarily, my lord, my argument would be that these are issues of pure issues of law, my lord. Fact, but even to enter into the issues of law, I'll have to apprise your lordship the basic facts only. Therefore, my lord, I am taking a lordship to this annexure, not trying to make any ground out of it, my lord. Just to give an idea that how this case has evolved, my lord. But I'm not making all this as a ground for quashing, my lord.
Okay.
Now, my lord, after taking this loan, a dispute arose between the parties regarding the interest amount, my lord, and it happened so that the loan could not have been repaid within 3 months' time. Therefore, my lord, the other side, they issued a legal notice to me at page number 35. On 10th of May 2018, a legal notice was issued to me demanding 5 lakh rupees. My lord will come to the relevant part at page number 36, the last para. 5 lakh rupees with agreed interest. The third line, last para.
Yes.
So she was claiming 5 lakhs along with the agreed rate of interest. Now, my lord, after I received this legal notice, my lord, I have issued a check, my lord. Now, my lord, the check, I have issued a check of 7 lakh, my lord. The check your lordship would find at page number 37, my lord. Now, my lord, your lordship is there at page 37. This is the check, my lord. Now, my lord, in all fairness, I must indicate, my lord, there is a mistake in this check. My lord will see when this check was signed on the right hand side below the signature,
Date.
8/6/2018. And your lordship will see the date of the check mentioned on the right hand side top, 2016. Now, my lord, this check was handed over to a person who is to a person who was acting as a mediator between both the parties, my lord. And this oversightness was even, my lord, the mediator who have accepted the check, even he overlooked this mistake. 6 became 8. My lord will kindly come to page number 88. Page number 88, because it's a part of the chart sheet. So page number 88. My lord is there.
Yes.
Now, my lord, this is the person who has accepted the check on behalf of the informant. I received a SBI check number such and such amount of rupees 7 lakhs from
He's the mediator or the info?
no, my lord, this is the informant. He's not the mediator. That I skipped that, my lord.
Okay.
Actually, but it was handed over to the mediator, and the mediator has also accepted it, my lord. There was no complaint made at that time, and thereafter the mediator has given it to the informant, my lord. Now, my lord, after this check was issued, my lord, I was getting repeated calls that I'll have to pay this and there is some anomaly. At page 38, I have issued a legal notice to the other side saying that if you want the check money, kindly collect it within 15 days, page 38, that kindly collect it within 15 days, failing which I will not be liable for any interest. Page number 38, my lord.
Yes.
The relevant part, I'll take your lordship to page number 39, last para.
Why this legal notice was issued? Why?
Because, my lord, I was getting constant call from the other side.
By that time, you were not knowing that there is a discrepancy in dates.
No. When it came to my light, when it has come to my lord, in fact, this dispute is not with regard to this, my lord. These are just the preliminary facts, which is the dispute is something else, my lord. I'll come to that, my lord. These are the basic facts, my lord, because that as far as the money is concerned, my lord, I was willing to pay the money.
Okay.
I never denied receipt of money, even as a counsel appearing before your lordship, my lord. I am accepting on behalf of my client that I received the money. The dispute is not that I have not returned the money or I have. I'll come to the dispute later. Now, take notice that further delay in repayment, that last paragraph at page number 39. Take note that further delay in repayment of money aforesaid, my client shall not be held liable in any case because my client has already presented 7 lakhs in check to your client for settlement of the case. Further, if your client wishes to accept the check value of 7 lakh, he may obtain the same within 15 days. I have also informed him that if you want the value, take it from me within 15 days from today. Otherwise, under the instruction of my client, I will file a criminal case before criminal court of law against your client without further intimation after receiving of this notice. So, my lord, my intention was communicated by my counsel that I am willing to repay you along with your interest. In fact, more than your interest, 620 was the interest. Be that as it may, my lord. Now, here comes the issue at page 40.
Page number
40. Now, my lord, while all this was happening, my lord, suddenly, my lord, my client got a notice from the Extra Assistant Commissioner, Itanagar, regarding a mail meeting. A mail proceeding has been fixed on 20/10/2018 at 10 a.m. at Mailghar, Naharlagun for settlement of money dispute. My lord will kindly take note of this word. For settlement of money dispute case in between such and such and such and such. Now, my lord, the money was taken from the wife of this person, my lord. Sri such and such, my lord will see the money agreement, my lord. It was his wife. The money was taken from his wife, my lord. Therefore, all the contending parties of the said money dispute case are hereby directed to sit in the Mailghar, Naharlagun.
This is that money with regard to which you issued the check.
Absolutely.
Okay.
Absolutely. They went to the Kebang.
Okay.
Now, here the Extra Assistant Commissioner is apprising me regarding the date of the Kebang meeting, my lord. Page number 40, my lord. Now, my lord, petitioner challenged this mail order because and subsequently page number 41, my lord, the mail meeting was adjourned, my lord. Now, my lord, the petitioner has challenged this mail meeting on the ground at the last page. Your lordship will see 112. On this ground, we have challenged this mail meeting before the Honorable High Court. At page number 112 is the notification. My lord is there at page number 112.
Yes.
This is the notification dated 6th of January 2014. This notification says that consequent upon the appointment of 5 Chief Judicial Magistrates come Civil Judge, Senior Division, and 5 Judicial Magistrate come Civil Judge, Junior Division by the state government, and subsequent posting of the officer and vesting of power in them by the Honorable High Court by notification dated such and such, such and such, such and such respectively, the Governor of Arunachal Pradesh, in consultation with the Honorable High Court, is pleased to order that the Deputy Commissioners, where the said judicial officers are posted, shall transfer all pending cases, both criminal and civil, to the court of the said Chief Judicial Magistrate cum Civil Judge and Judicial Magistrate cum Civil Judge for trial and disposal thereof. Henceforth, all cases, both criminal and civil, shall be instituted only in the court of Chief Judicial Magistrate cum Civil Judge, Senior Division, and Judicial Magistrate cum Civil Judge, Senior Division. Therefore, my lord, since 2014, the village authorities lacks jurisdiction to try civil or criminal cases where there are.
No, it does not speak about village.
My lord,
It speaks about the earlier when it was not separated. That is my understanding.
I will take your lordship to a judgment passed by Honorable Justice B.K. Sharma, my lord, where
No, on the where perusal it appears.
My lord, this judgment was clarified by our High Court.
This notification,
Sorry, was clarified by our High Court, where the High Court has invoked the principle of implied repeat.
So now Kebang does not have jurisdiction.
In places, my lord, I'll take the lordship to this judgment. In places where there are regular criminal courts and civil courts.
Everywhere regular
Then
courts
if
are
it is in everywhere, because it says in places, my lord, so I'm going by the letters of this notification. If it is in every place, then my lord, civil and criminal disputes are to be adjudicated by regular courts of law since 2014, my lord.
Okay, but where perusal appears that the cases which were pending before deputy commissioners are to be transferred to the judicial courts.
The deputy,
That appears.
my lord, the jurisdiction of the because deputy commissioner is also an appellate authority under the Assam Frontier Regulation Act, my lord.
Okay,
So, my lord, deputy commissioner will henceforth have no jurisdiction, my lord, to try any civil or criminal dispute either in the original side or in the appellate side,
okay. That is clear.
my lord. So, my lord, in Kabang, if the parties sit and settle mutually, my lord, that is a different issue altogether, my lord. But, my lord, if the case goes for any, if it comes to the door of the deputy commissioner or the assistant commissioner, my lord, for any type of adjudication, my lord, then probably, my lord, if I go by this notification and a judgment of this Honorable High Court, my lord, where the principle of implied repeal was used, that particular regulation was impliedly repealed by this notification. That what our High Court has held, man. My lord, these are subject matter of the writ petition which is pending.
Okay.
And in that writ petition, there is a stay order operating, man.
No, but what is your submission that it repeals the jurisdiction of Kebang? Is it your submission?
My lord, my submission is that, my lord, the order passed by the deputy commissioner in this, extra assistant commissioner in this case, my lord, he could not have passed it in view of this notification.
Issuing notice that regarding village mail.
Yes, and then, my lord, I'm coming to the other annexure where he was literally trying to act as an executing court. He was literally issuing notices one after another, directing me to comply the decision of the Kebang.
Okay, otherwise you have challenged this notification.
Well, this notification is my favor. I'm not challenging the notification. I am
This
challenging the
notification has been clarified by some judgment of the High Court.
the judgment of this court, and my lord, whether
What is under challenge? You said that some writ petition is pending.
my lord will just bear with me. I'll take your lordship to the annexures, my lord,
Okay,
in a chronological order, my lord, one after another. My lord, what is subjudiced before the single bench of this Honorable High Court in a writ petition is the decision of the Kabang from where this entire case had emanated. The foundation of this case, whether the decision of the Kabang post 2014 and the subsequent orders passed by the deputy commissioner and assistant commissioner, whether those decisions will be binding of post 2014 notification is the issue under challenge and subjudiced in a writ petition before this court, my lord.
okay.
Now, my lord, at page 40,
Where is the notice which you received from ADC?
my lord,
Page
page
38.
40, my lord will kindly come to 40.
Okay,
40,
this is under challenge in a writ
my
petition.
lord, all subsequent notifications are under challenge because, my lord, there are a couple of more orders passed by the assistant.
In respect of this case.
It's same case, my lord. Same party,
Between
same money dispute.
Taking Talom and Obuk Mize.
Yes, my lord.
Okay,
Now, the money was taken from the wife. The husband has entered the shoes of the wife and is initiating all this proceeding.
okay.
Now, my lord, when this notice, when I initially received this notice, my lord, I had challenged it before the High Court, my lord. Now, my lord, at page number 42, my lord will see, I had intimated to the extra assistant commissioner regarding filing of WPC. After receipt of this notice from the extra assistant commissioner regarding the mail meeting, my lord, I have issued this representation, page number 42.
After receipt of the notice under page 40, you went to, you
High
came
Court.
to High Court.
High Court.
Thereafter, you intimated
the Kabang that I have challenged it before the High Court, and therefore you should not proceed, my lord, because the matter is subjugated. Notwithstanding that, my lord, they have proceeded. This is the
whether
communi-
there was any stay in
That is precisely, my lord. In that case, only notice of motion was issued.
Okay.
So since it was not stayed, therefore they went ahead with the mail decision and a mail decision and which has culminated into a mail decision, my lord. Now, my lord, will see what was the decision taken in the mail order. Now, my lord, since they went ahead with the mail decision, therefore the writ petition became infructuous because the notice was issued. Now, either I have to challenge the mail decision, that petition has become infructuous in view of the fact that a subsequent event had taken place. That is, they had already issued the mail notice. So I had withdrawn that writ petition. My lord, will see at page number 46. Page number 46.
Yes. That was withdrawn.
Yes, that was withdrawn. And on what ground? Because it has become infructuous. It is reflected in the order. So I take your lordship now to the mail decision at page number 47. Now, my lord, it would raise probably your lordship's eyebrows, my lord, if I take your lordship to the amount which the mail has directed my client to pay because of a loan of 5 lakh rupees. My lord, will kindly come to page number 49. Para E.1, my lord will see. Para E.1. Since the absent of the opposite party is intentional, that as per the money received written by himself and promised such and such by the opposite party, the members have no alternative to plead on his behalf. So the total claimed amount of the complainant are to be found correct, and accordingly, Sri such and such is directed to return a sum of money 20 lakhs, 20,000.
Okay. Okay.
5 lakhs became 20 lakhs, 24. Now I take your lordship now, my lord, this mail decision was placed before the extra assistant commissioner who issued order of payment at page 52. My lord will see the last line. The extra assistant commissioner writes to my client at page 52.
Yes.
Below, my lord.
Which
In
is
view-
the executing authority of,
My lord, my submission is that, my lord, it has to be in a regular court, my lord. That order cannot be executed, my lord, because that order lacks jurisdiction.
no, you are challenging the
I
mail
have
decision.
challenged the mail order. I have challenged the order, the orders.
Let me understand. Otherwise, what Kebang decision, who is the executing authority?
Your lordship, at that point of time, your lordship, the village, this mail only, the Kaba village authority only, they
No,
execute.
not this case. I'm not on this case.
At that point of time, your lordship,
Nowadays, whether Kebang is
now your lordship is the executive
resolving the
magistrate.
dispute.
Now is the executive magistrate, your lordship.
Kebang is not in,
Your lordship, there are many amendments in the AFR also, your lordship, and Arunachal Pradesh code has been introduced in the meantime, your lordship. But at that point of time, when mail has been conveyed, your lordship, On the earlier,
We will come to case later on after hearing his submission,
Not on the. facts
but
of this case.
not on the facts.
okay, Your Lordship.
Otherwise, Kebang and Mail and Nile, they are deciding disputes between in the customary courts now or not.
Yes, Your Lordship.
It is
It's still there, it's still prevailing,
still in
a practice.
practice.
Yes, Your Lordship.
Who is the executing authority?
The
Who
very
is-
Kabang,
The-
the very village authority.
No, you are from Guwahati. I am asking people from Arunachal. Not to discriminate, but they may be knowing better how it is.
Your Lordship, Deputy Commissioner, Your Lordship, the executing.
Is there any rule?
Yes, Your Lordship. As for the AFR, Your Lordship, this now presently, Your Lordship, the AP code has been introduced, Your Lordship, Arunachal Pradesh Civil Code.
What is the impact of that AP code?
Your Lordship, the jurisdiction of the Deputy Commissioner, it has been repealed, Your Lordship, in the AFR, Your Lordship. It will substitute by the session judge and Your
That
Lord.
means appellate forum is now
This, yeah.
DC and
Civil-
district judge. District
Yes,
judge or
exactly, Your Lordship.
commissioner.
Yes.
And executing court is who executes the order of the Kebab?
Executing Your Lordship, Deputy Commissioner, his Deputy Commissioner is only the executing court, Your Lordship.
Okay. You may proceed.
I'll take your lordship to the relevant provision of the AFR also, my lord. And I'll demonstrate that, my lord,
Your submission is that DC does not have jurisdiction. Kebang does not have jurisdiction.
post 2014, they do not have jurisdiction, my lord. My lord, I'll take your lordship to the relevant laws, my lord. I have the judges at page 52, my lord. Here, the extra assistant commissioner has assumed the role of an executing court. It may not be exactly the word executing court used, but in essence, he is trying to execute it. At page 52, the last line, in view of the above, you are hereby directed to deposit the aforesaid amount to the undersigned without fail. Now, my lord, thereafter, my lord, he issues a show cause notice to me. My lord, under what provision these notices and these orders are issued, my lord? There is no mention of any provision of law under which the extra assistant commissioner is issuing all these orders. Page 53.
And therefore I asked, what is the executing authority under Kebang system?
My lord, as far as my knowledge goes, my lord, after 2014, my lord, the deputy commissioner or the extra assistant 2014 and the extra assistant commissioner, my lord, they cannot discharge any judicial function, my lord.
Including the execution.
Including the execution, civil or execution is a part of CPC, my lord, the civil procedure code. The word used is civil and criminal cases. So even execution will come within the periphery of civil cases, my lord, because execution is enforcement of a civil decree.
And customary courts like Kebang, Nile and Mail, whether
they will also lack jurisdiction to decide civil and criminal cases, my lord. As of date, my lord, I'll be stand corrected if there is anything otherwise. To whatever my little understanding goes, my lord, post 2014, and that is the precisely, my lord, why all this execution and everything has been stayed by this High Court. Because
Okay.
there is, I'll take your lordship to the executing order as well,
proceed.
because this case was put for execution. Now, my lord, this was the show cause notice again issued by the same authority. Hence, you show cause as to why necessary action should not initiate against you. Your reply such and such that he has now show caused me, my lord. Now, my lord, the present criminal case which is under challenge has emanated from this reply to this show cause notice at page number 54. Now, while I furnished reply to this show cause notice, my lord, page number 54.
Yes.
Here, my lord, along with the reply, my lord, a photocopy of the check was annexed, my lord. Will kindly see page number 85.
Same check where the dates were,
Yes, but in this check, now the date, which was originally 2016, became 2018.
you corrected the date.
Now, my lord, I corrected or somebody corrected at the office, my lord, that is to be decided.
You
by
have not
evidence.
corrected.
I have not corrected. Because the original check was in the possession of the other side. It was not in my possession. The check was not in my possession. Now, here, 6 became 8 on the right hand side top, if your lordship have seen.
Yes.
Now, my lord, this
Reply to show cause was submitted by you.
the reply to show cause was submitted by me. In
And
that,
this check was also annexed with this show cause by you.
my lord, the check, my lord, because I do not, because there is no order sheet of when the reply was submitted, when this was detected, FIR was filed after 1 year. I'll come to all this, my lord. If there has been anything of that sort, my lord, the FIR should have been gone promptly, my lord. Here is a case where the FIR is lost after 7 years and 10 months.
Now, what is the allegation? In
Now,
that?
I'll just, my lord, I'll come to that. Now, my lord, this is the reply to the show cause notice at page number 54. Now, the extra assistant commissioner even resorted to police, my lord. My lord, from where he is assuming this jurisdiction,
How this reply is relevant? You took some stand.
I took some stand that I have paid the money.
You have issued the check.
I have issued, paid the money in the sense I have issued the check. He is not accepting. Even I have sent him legal.
These things you have narrated
Yes,
in.
that even I have intimated him through my lawyer that if you need the money, come and take within 15 days.
Okay.
What was, my lord, if I understand it, my lord, all this CRPC, IPC, Kaban, I have taken a money from somebody, I need to pay it. I said I am willing to pay it.
Okay.
Come to me, I'll pay the money. Now, my lord, at page number 57, an order is passed by the extra assistant commissioner directing me to appear on 20 of August 2019 at 11 hours for a personal hearing. Now, my lord will see the conduct of this authority, my lord. I am a resident of Pasighat, my lord. Now, my lord, this order dated 7/8/2019, where I am directed to appear before him on 20th August 2019, was posted to me on 20th August itself. The postal receipt is annexed. It will be further clear from page number 58.
Okay.
It will be further clear from page number 58. The postal receipt date is there, ma'am.
Yes.
Now, my lord, now comes the impugned FIR at page number 59.
Yes. What was the allegation?
Yes. Now, my lord, two things. Who lodges this FIR? The FIR is lodged by the lady from whom I have taken the loan, not by the government servant, nor by the extra assistant commissioner. Assuming that the mail meeting is in accordance with law, assuming that the extra assistant commissioner have jurisdiction under the AFR to act as an executing court or to act as an appellate authority. In that event, my lord, the law requires that a complaint has to be filed by the public servant or by the court before whom these offences have alleged to have taken place.
Offense of.
This is an
rendering
offense.
false evidence.
Yes, as well as 465 forgery.
For 465 also.
Yes. This 195 subsection 1 subclause B.
Forgery where in.
Because the allegation is that the forgery has taken place before an judicial proceeding.
Okay.
The show cause reply was so assuming that the mail order is in conformity with the requirement of law, that the show cause notice and everything are passed within the authority of the AFR or any law holding the field in that regard. Even then, this FIR is hit by 195 CRPC. That was my first limb of argument.
No, what is the allegation?
Allegation, I'll read the FIR. I'll read the FIR. The
Instead of
allegation
reading,
is short.
you can tell me the crux.
Crux.
Gist you can tell me.
Crux is that the FIR contains two parts. First part, she narrates about my
Taking of loan.
loan and not paying and all these things. Second part, she says that I have initiated a proceeding
Cabal proceeding.
before that, then it has gone to the extra assistant commissioner. From extra, there was a show cause notice issued by the extra assistant commissioner, and in that proceeding before the extra assistant commissioner, he has submitted a check where 2018 photocopy of a check where 2018 was made at 2016. 16 was made at 18. So
That is the allegation.
that is the allegation.
Okay.
And interestingly, even this FIR, because this FIR has been definitely drafted by someone who is instructed in law, because this FIR itself contained 195 at page number 60. The delay is being explained on the pretext that this paragraph, my lord, I'll kindly request your lordship to read this paragraph. In view of the bar under 195 CRPC 1973, she herself is admitting, I could not have directly lodged an FIR to the police, and I have waited the EAC office Naharlagun, believing that they would lodge an FIR against the such and such as per section 195 CRPC. However, even after waiting for 10 months and when the FIR was not lodged by EAC. Now, my lord, whether a person will assume jurisdiction because of lapse of time, my lord.
Okay.
So,
Even after delay, you cannot assume jurisdiction.
No.
That is your submission.
yes, my lord,
Okay.
because there is no rider in 195
Because statute gives power to a particular.
authority. And if a thing is mandated to be done in a particular manner, then it has to be done in that manner or not at all. That's, my lord. Those are, my lord, settled principles. My lord, your lordship is aware, my lord. Now, my lord, this FIR was initially registered, my lord will see under section at page number 60, 420, 467, 465, 471 IPC. Now, my lord, will just excuse me. I'm a diabetic, so I get this.
No issue. No issue.
It gets dry, my lord. Then this FIR had culminated into a report under 173. That is the charge sheet at page number 61, my lord. I'll not take your lordship to all this 161 statement and this, because these are neither my grounds, my lord. Now, my lord, we'll kindly come to page number 103. Now, before that, my lord, I'll have to show to your lordship that now this was not registered as the circle officer have made a complaint of cheating and forgery to the officer in charge at page number 102 in the year 2020, page number 102. But this complaint, page number 102. In the year 2020.
What is this?
This is an information, I would say, because this was not registered as a case. 2020, with the subject ever cited, I am to state that it is quite evident from the finding in your enquiry report dated such and such that Sri such and such has committed cheating and forgery in the instant case. Therefore, you are directed to register. My lord, this was neither registered as any PS case. My lord, this was more in the nature of an statement during a statement under 161, I would say, my lord, because it was during investigation, my lord. It was neither registered, nothing. And he has written to the officer in charge. 195 says complaint, and complaint is defined under section 4D. complaint is in writing before a magistrate.
No, you are saying that this is not the complaint under section one.
No, no, because it was neither registered, neither it was acted upon. The FIR lost by the lady from whom I have taken money, that was registered and the charge sheet was filed on that basis. Because the corresponding PS case number in the charge sheet is also the same case number which was assigned to that FIR lost by the private party, my lord. Now, my lord, I take your lordship to page number 103 for a while, my lord.
Yes. No.
I challenge the charge sheet, my lord, because I have disclosed all the facts here in this petition. I challenge the FIR in this criminal petition, my lord. But since charge sheet was filed, therefore, my lord, the court was of the opinion that we should go and argue during framing of charges, and accordingly, this petition was withdrawn, my lord, since charge sheet was filed. Now, my lord, thereafter, this is the impugned order, my lord, at page number 105.
Charges are framed.
Yes. Charges are framed at page number 105.
Yes.
Charges are framed under section 106, if your lordship sees. Charges were filed under, charges were framed under section 465 and 193 para 2 of the IPC, which is there at page number 106. Now, my lord, after now, in the meantime, my lord, in the year 2000, that your lordship says that the executing court, I was making a submission that the execution court is the village authority itself, my lord. I made my submission on the basis of page 107. This is the notice of execution application, page number 107, my lords. And this is by the court of Model Village. The learned public prosecutor said that the Model Village, so I adopt his submission for that matter, my lord. He said that the Model Village is not the executing court, therefore this lacks jurisdiction, my lord. Now, my lord, this executing this order of execution plus the entire mail decision and all show cause notices were put to challenge at page number 108.
By you.
By me.
Okay. What has been challenged? This
order
107.
107 plus the mail decision, which is at page number, my lord, 47.
Then
The Honorable High Court
have you
on,
also challenged the notices issued to you by
yes, my lord,
the
extra assistant
Extra
commissioner. Precisely, my lord, page number 109 for your lordships. This is a half paragraph, my lord. Here, I have initially challenged the order dated 2/11/2018. 2/11/2018 is the mail order, mail meeting order, 2/11, that the mail decision. And these are the impugned order where I was directed to deposit 20,00,000. And these are the mail orders. So including the execution application number 9/2022 was put under challenge. This honorable court, after hearing the parties at page number 110, have stayed In the interim, execution activation number 7 purportedly pending before the customary court of Model Village, Naharlagun, stayed till returnable date, my lord. And I am told that, my lord, it is still pending adjudication before this court and the interim order is being continued.
And what happened to the matter which was pending before EAC?
Now, my lord, the matter
It
pending.
appears that before the customary court of Model Village, Naharlagun, also executing proceeding was going on. And EAC was also proceeding with some execution process.
My lord.
It's
Now that case, that now as on date, my lord, I have, after stay of this, I have not received any notice either from the extra assistant commissioner or from the,
okay. So your submission is that as the High Court has stayed the Kebang decision,
my lord.
and as you are you have challenged the FIR on the basis that 195 CRPC has not been followed. You have put that challenge in this instant.
Absolutely, absolutely.
Therefore, what is your prayer that?
Now, my prayer is for quashing of the order framing charges, quashing of the FIR, quashing of the charge sheet, quashing of the order on 2 grounds, my lord. Ground A, that the very foundation is under challenge, my lord. And once the foundation goes in a criminal case, the entire structure falls, my lord. I will take the lordship to a relevant judgment, my lord, where exactly this word is being used. This is one. Second, assuming or presuming that the mail meeting is valid. If tomorrow the High Court holds that the mail meeting is correct or valid, and the extra assistant commissioner has the power to assume the role of whether to use the term executing court or appellate authority, my lord. In that case, if these orders are valid, if tomorrow my writ petition is dismissed, in that event, my lord, this proceeding is hit by 195 directly. In either way, my lord. First, my submission, this mail meeting lacks jurisdiction in view of this order, my lord. In view of the notification on 2014.
Okay.
Now, my lord,
Anything more?
no, my lord, let the public prosecutor make his submission, my lord, because yesterday there was a similar case, my lord, while I was waiting for my unlisted item, my lord, where that some people entered a police station, my lord, where similar type of offenses was alleged, and where, my lord, this 195 argument was, in fact, it has fallen from the learned public prosecutor, my lord. So, taking a leaf from his argument, my lord, yesterday, my lord, even, my lord, in this case also, my lord, this ought to have been filed either by the extra assistant commissioner or somebody subordinate to him.
Your lordship, at the outset, your lordship, I will distinguish the 195, your lordship, the provision 195. Here, your lordship, under section 193.
Yeah.
I'm directly coming to this because, your lordship, this is a criminal petition, your lordship, where I have to satisfy this court that there is a prima facie case, your lordship. So now, as my brother has, your lordship, apprised this court that this case is hit by section 195, your lordship. 195, your lordship, even in 195 subsection 1, it directly says 172 to 188. This is a mandatory provision where, your lordship, the court cannot, the police cannot register any FIR without any complaint. But the second part is B1 and B2. In B1, the offense, if it is committed in any court proceeding or in relation to any court proceeding, it says 1, that subsection, subclause 1, your lordship. And the second is, your lordship, the offense described in section 462 or punishable under section 471, 475 or 476 or the said code, when such offense is alleged to have been committed in respect of the document produced or given in evidence in a proceeding in any court. It says, your lordship, the document which has been produced, because the learned court below has charged him under section 465, your lordship. That 463 is the definition of forgery and 465 is the punishment. Here, your lordship, now the issue here is The document, as per the, your lordship, interpretation given by the honorable court, the document must be in the custody of the court, your lordship. If it is produced from outside, then 195 will not operate. It is a judicial pronouncement where Supreme Court has, your lordship, distinguished, your lordship. If it is in the custody, suppose this writ petition is in the custody, if I manipulate this writ petition when it is in the custody of the court, then, your lordship, the bar under section 2 will, your lordship, 195, the complaint is mandatory. If it is come from outside, if already manipulated and comes, then, your lordship, 195 is not required at all, your lordship. So why I am submitting here in this case, your lordship, this case survive, your lordship. Why? Because initially the cause of action arise, the mail cover, whatever has happened is gone, your lordship. But the time when the show cause notice comes, in that show cause notice, in reply, he has manipulated the check. And initially he has, to discharge his liability, he has issued a check, expired check, your lordship. It has been maintained in the right side, your lordship. I will come to the material also. On 2016 check, 16 check has been issued in 2018, your lordship. The validity of check is 3 months, your lordship. It's invalid check. So from that, your lordship, it can be presumed that he has a fraudulent intention or dishonest intention right from the inception, your lordship. He has taken money, and when the time comes to discharge his liability, he has given a invalidated check, and subsequently, your lordship, before the executive magistrate, when show cause notice has been given, that has been manipulated, your lordship. It was
His submission that initially, due to oversight, he is admitting his mistake that he put wrong dates on the right hand side, and under his signature he put a wrong date.
your lordship.
That he is submitting.
Yes, your lordship.
But he is not admitting that he has manipulated.
Your lordship may come to the 161 statement, because at this stage, your lordship can peruse the document, whatever is there before the court, your lordship, on the basis of the document collected during the course of investigation, your lordship. Your lordship, in 101, your lordship. My learned brother has submitted, he is not aware who has corrected it, your lordship.
Yes.
Your lordship, in a question, your lordship, on 4th paragraph, your lordship. In your reply to show cause notice dated so and so, submitted to ESC Nalagan, you have annexed the copy of the same check bearing serial number so and so, which you have given to Taking Talom, and in the copy of the check submitted to ESC Nalagan, you have mentioned its issue date is 18/6/2018, while in the original check it is 18/6/2016. Also in your written reply at paragraph number 2, you have mentioned the issue date as 18/6/2018. Why you have done this? At the time of issue the check to so and so, I have kept the scanned copy of or photocopy of check with me, and after observing the date of issue as 18/6/2016, I have corrected and made it as 18/6/2018. In the correspondence related to the said case, I have annexed the copy of the check. Here, your lordship, prima facie case is made out, your lordship.
When he has corrected it.
When he has submitted to the, at the time, show cause notice, along with the show cause notice, my learned brothers has already shown to your lordship, your lordship. Show cause notice to the ESC, your lordship. And after that only, your lordship, the original, after lodging of the FIR, the original check was seized from the payee, your lordship. Then it was manipulated, forged before your submission before the court. If it was manufactured or it was forged when it was in the custody of the court, then 195 is mandatory, your lordship. The prima facie case is made out, your lordship. If this single statement can draw a presumption, your lordship. I'm not saying he is guilty of this. This is subjected to the trial, but presumption can be drawn, your lordship.
Where the original check was.
Which the custody of the, your lordship. Your lordship may kindly see the charge sheet. It's clearly written in the charge sheet. It was after the lodging of the FIR. FIR comes on the later stage, your lordship. Or during the course of investigation, it was seized from the custody of the, your lordship, payee, your lordship, to whom he has given the check, your lordship. The complainant.
Corrected. If it is in the custody of the informant.
Yes, your lordship.
how he corrected it? He has corrected only in the photocopy.
Yes, sir. Photocopy, in photocopy, he has corrected, and photocopy he has given to the, your lordship, produced before the concerned authority, ESC, your lordship.
Whether it would amount to forgery of the original document, because the original check has not been touched. It
Yes,
is-
your
it
lordship,
is-
but your lordship, he has a intention, your lordship, cheating, your lordship, the forgery for the purpose of intention, your lordship, intention for cheating, your lordship, to mislead the, your lordship, ESC, your lordship. The intention is there, your lordship. And so far as the original check is concerned, your lordship, he has a liability to pay certain amount, which they are admitting, no
not
doubt, but
intention. It may be giving false evidence. It may be a case of giving false evidence, but forgery, because original check was with the payee.
yes, your lordship.
He could not have forged it because it was not with him. He only tried to give a false evidence by giving a document which was not true. Is it a case of 465? 465 will be applicable only in case of the original document.
It's manipulation in the original document.
Manipulation.
Yes, your
There
lordship.
is no manipulation in the original document. He tried to give a false evidence by giving a separate photocopy, making corrections in the photocopy. If it is a case of false evidence, then 195.
It's false evidence 195 count, but your lordship, so far as 420, then your lordship, the cheating, your lordship, the ingredient of cheating, your lordship.
Charge is not framed under photo.
His death is there, but your lordship, so far as 482 is concerned, the court has to see the prima facie, your lordship. And your lordship, even if the charge is framed under your lordship, 465 or 193, it can be altered on a later stage, your lordship, if anything's come, because 216 is there. The learned court below is clothed with the power under section 216, your lordship.
Whether respondent number 2 is before us now.
I'm appearing before respondent number 2, Lordship.
This cannot be disposed of today itself because it is in motion stage. We have to admit it, issue notice. Though you are appearing
Yes, Lordship.
on your own.
No, Lordship, on under instruction, we'll be filing our wakalatnama during the course of the day.
You have been notified by the petitioner.
No, Lordship,
We will be submitting any reply.
Lordship, we have not been
Objection.
furnished, as this is the motion state, we have not been furnished with the petition copy, Lordship.
Yes.
After
No,
perusing the
what I
petition.
intend to do that issue notice. But apparently there are some questions raised which needs inquiry during this proceeding, which needs to be looked into. And questions raised are not such that it does not have any basis. Apparently, they may succeed, they may not succeed, but there are some materials.
Death is there, your lordship.
And the Kebang decision.
Your lordship, if we go to Kaba decision, then this matter is sub judice, because if the learned,
That is sub judice, that has been stayed.
yes, your lordship. So
Right.
that is not, they didn't reach its finality, your lordship. So if we go, we cannot rely on that, because since
But
it is
this
sub
is
judice,
connected with that.
if it is sub judice, then this is premature, your lordship.
No,
Anything will come out from the final, your lordship.
this is not against the Kebang decision. They are only against the criminal proceeding, which
Yes,
is
yes.
based on the Kebang decision.
Yes, your lordship.
So if Kebang decision is under challenge, the criminal proceeding, at least till the hearing is done, needs to be kept in abeyance. That is my view.
Yes, your lordship. What my, your lordship, humble suggestion is, your lordship, this matter is fixed on 6th of October. You still have 1 month, your lordship, in between. So in the meantime, your lordship, LCR is from here only, your lordship.
So we will call for the LCR.
Yes, and before that, the date may be fixed and we go for final disposal of this case, your lordship.
Whatever you suggest, but during that period,
There's nothing coercive.
Your lordship, before 6, there will be no any proceeding before the learned court below, because date is fixed on 6, your lordship. 6 October, your lordship.
but let there be a formal order.
Yes.
or you don't want? Otherwise, if we fix it before six, then there would be no need for
Yes, your lordship.
stay. That is his submission.
Yes.
My lord, if the matter is fixed, if he is,
6th of
6th of October, your lordship.
if the matter is because today is
6th of September.
because respondent number 2 is
already
appearing,
entered.
appearing on his own without he has not gone through your petition. He needs time to reply
My lord, I am,
and you will suffer no loss. That
Right.
is their submission, even if no interim stay is granted, because matter is already charges are framed. Matter is fixed on 6th. If this case is fixed before 6, if on that day the decision is not taken,
my lord,
then you can press for.
Yes.
my lord,
Question of interim stay would come. You make me clear if I am wrong.
Yeah, I'll definitely.
If there is some urgency.
My lord, I'll clarify, my lord. What he's trying to essentially say is that on 6th of October is the date, your lordship will fix a date before 6th of October. Until 6th of October, nothing is going to happen because the next date before the trial court. And after receipt of the LCR, this matter may be finally disposed of. The apprehension is this matter. If suppose on the date fixed by your lordship, this matter could not be heard, then my lord, my request would be that if your lordship observes that will also safeguard me, my lord, the way they should not be prejudiced, this man should not also be prejudiced. If your lordship observes that on the next date fixed, whatever date is convenient to your lordship, subject to your lordship's roster and whatever date is convenient to the parties, my lord, your lordship will fix a date and your lordship will make clear that in the event the matter is could not be disposed of on the next date fixed, then
Interim may be considered.
that
Interim may be considered.
then the interim, then the otherwise, my lord, if your lordship says that till pendency of this, that even that will not harm them, my lord, because my lord will fix a date, giving an interim, your lordship will fix a date before 6th. On
No,
the
normally what happens if once we issue interim, it becomes difficult to vacate. It goes on.
Yes, yes.
Then you take dates, then you take mention, you make mention, and it goes on for 6 months. That because they have so moto appeared, let us hear them
my lord,
on your.
my lord, what I'm submitting is that your lordship may make an observation to that effect. That no adjournment will be given on behalf of the petitioner on the next date. I am obliged to. I am not trying to bargain time. My only apprehension is that, my lord, because of the roster
No,
yesterday. also,
regarding
my lord-
adjournment, that is
My lord,
difficult.
my lord, what I'm,
Okay, I'll make some observation
That-
regarding interim, that interim may be hard, even if.
now, my lord, the apprehension is this, my lord. If the matter, because my lord, yesterday also we have seen some matters were left over, my lord. We cannot say a judge, my lord, that you take up my
Yes,
matter. We
yes.
cannot say it to a judge, my lord. It's difficult, my lord. So, my lord, if the matter for reason whatsoever is not called upon that day, my lord, my client will suffer prejudice, my lord. Therefore, my lord, what I am saying is that, my lord, for the interest of both the sides, my lord,
What is the submission?
your lordship will fix a date before 6th. Before 6th, your lordship will fix a date. I will argue on 6th before whatever date is
Final hearing.
But my lord, your lordship will grant an interim order, my lord, because my lord, if that matter could not be called up, so that this man is not prejudiced.
Your submission is for final hearing.
Yes, Lordship. We only need time to peruse their petition and make our submission. And my lord may kindly see that the order is of June. They are coming in the month of September and asking for interim, Lordship. If they had come in the month of June itself or July only, this matter could have been disposed of way back, Lordship.
That would not-
That was something to be considered. There's urgency if they're talking about urgency, Lordship. That we are making a humble request that Lordship a day, any data after 20 may be
My
fixed, Lordship. It will give us sufficient time, Lordship, because the matter is fixed on 6th October, Lordship. So it will give us them also sufficient time, that Lordship. The
You
hearing
want-
can be done.
When you want it to be fixed.
Any date after 20 September, Lordship. It will give us sufficient time, Lordship, to go through the petition and file anything.
Your lordship, why I'm saying so, because your lordship, if suppose they succeed, if suppose on 195 they succeed, the party will not be debarred from filing a complaint by approaching the concerned authority, your lordship.
Yes.
That is there. That is the reason, your lordship,
even I wanted this matter to be disposed of early, because one interim is granted. The matter may drag for, I'm not alleging anyone, but matter may be dragged further, Your Lordship. This is the reason I think the 1 month is sufficient to prepare a case, Your Lordship.
My lord, I don't think passing of an interim order is something alien to this judicial system, my lord. It is not that if an interim order is passed, heaven will fall upon the earth, my lord. What I am saying is, my lord, my submission is that I am
Because
agreeing.
even if today we don't consider interim, if the matter could not be taken up,
Yes,
then they will again come for interim. What
what is the point?
heard Mr. M. Bishas, learned counsel for the petitioner. Also heard Mr. T. learned additional public prosecutor, who for respondent number 1. And Mr.
G. Talo, Lordship.
G. Talo,
Yes, Lordship.
learned counsel who has made his appearance for respondent number 2. In this application under section 482 of the Code of Criminal Procedure, 1973, read with article 226 or 7.
This is 480.
You have mentioned 226 also. Read with under section 226.
The first title, man.
This is to confuse the court.
It should be 482 only. Your
Only
Lordship.
482.
Only 482.
482, my lord. In the first title. Read with 226, my lord. This is 482, my lord.
Okay. Under section 482 of the Code of Criminal Procedure 1973, praying for quashing of the order dated 16/6/2023, passed by the Court of Learned Chief Judicial Magistrate, Capital Complex UPA in GR case number 477/2021, corresponding to Naharlogun PS case number 95/2021 under section 465/193, para 2 of the Indian Penal Code. Issue notice to the respondents as Mr. T. has made his appearance. Learned public prosecutor has appeared for respondent number 1. No separate notices need to be issued to respondent number 1, as well as Mr. G. Talo has made his appearance for respondent number 2. No separate notices need to be issued. However, the petitioner shall furnish requisite numbers of copies of the petition under section 482 to the respondent side to prepare their objections and defend and case against the petition filed by the present petitioner. Let this case be fixed again on
Friday evening. Can it be on 29?
29 September 2023. Stop. As learned counsel for the petitioner has submitted that the criminal proceeding drawn up against the present petitioner, as the learned counsel for the petitioner has raised in this criminal petition a plea that the criminal proceeding drawn up against the present petitioner in GR case number 477/22 is barred by section 195 of the CRPC, which requires in-depth look which requires to be looked into by this court in depth in this proceeding. And as well as learned counsel for the petitioner has also submitted that the decision of the Kebang, where is the decision of the Kebang?
110.
Kebang on the, which is also relevant in this instant. Decision of the Kebang as well as decision of the extra assistant commissioner Capital Complex Nahar Lagoon, whereby the present petitioner is directed to deposit a sum of rupees 20 lakhs 20,000 to the respondent number 2, has been kept in abeyance in writ petition number 140/2022 by order dated 8/4/2022 of this court, which has an implication in deciding the present criminal petition. The operation of the proceeding of GR case number 477/2021 is kept in abeyance, in interim till next date. Let this case be fixed again on 20, which is the date?
29th of September.
29th of September.
Lordship, LCR.
Oh, yes. Let the LCR, let the scan copy of the LCR. Let the scan copy of the LCR of connected GR case called for from the
CGM UPR.
from the Court of Learned Chief Judicial Magistrate UPR.
Let me please, Your Honor. Your Honor, in the morning, I had mentioned item number 6 and 7 for adjournment. But then there was an interim prayer which was continued until the returnable date.
In item number 6 and 7, interim order shall continue till next day.
Obliged.
Where is the objector?
I was supposed to leave, I remain to appear. Well, I think objection was to be made by the respondent. Yesterday, my part, I argued.
Yes, he is not objecting today. Who's the lawyer? Mr. T. Tabo. Mr. T. I have already heard. He's not there in Mr. Ta.
He is supposed to make the.
We'll take it up after some time. Or I can dictate the order.
My lord has.
But he had some objections which we have not heard.
It should have been by now when the.
Let this be called up as the next item. Next item.
After some time. Next.
Lordship, the council is opted in Passover. He is coming.
Passover for the time being.
Yes, Passover.
We'll call it up
Fine,
after
next.
some. After some. Has he appeared before the IO?
Appear, Your Lordship. He
Yes.
sent everything recorded. Yes.
Cooperated.
cooperated and 41 a notice has been given, meaning thereby a custody interrogation is not required.
Yes. Certain.
You are also allowed to go on bail. You were arrested.
Yes.
This
Interim was granted.
interim was granted.
Yes,
So
yes.
whether actual arrest was made, whether you produce the surety or no arrest was made.
No arrest was made.
No arrest, Your Lordship. Statement and
Statements has been already recorded.
So what is your prayer now?
Now, Your Honor, my lord, since statements has been already recorded and there is.
Now there is no apprehension of arrest.
Yes.
Two
So,
things may be there. Either this bail has to be made absolute
yes,
if you are already granted bail.
yes,
If you are not granted bail, if you are not arrested, then there may not be any apprehension of getting arrest now. Then this becomes infructuous.
yes, Your Lord.
So what is your submission?
so.
It,
bail may be
as it
absolute.
becomes,
Yes.
no, it cannot be made or it may also be made absolute. What is your submission? Say it.
Your Lordship, the 41 notice has been issued, Your Lordship, and usually 41A notice is issued when the custody interrogation is not required, Your Lordship. And he has not been shown arrested after, Your Lordship, his statement was recorded. So if suppose he was shown arrested, Your Lordship, then Your Lordship, there is a possibility that again, the second time there is maybe an apprehension that he may be arrested again if suppose this bail has been, if he say that there is no any apprehension.
Okay. Therefore, it is good to make it absolute.
Yes, Your Lordship.
Heard Mr. G. Tadi,
Yes.
learned counsel for the petitioner, also heard Mr. T. Ete, learned additional public prosecutor. Learned counsel for the petitioner, Mr. Tadi has submitted that by order dated 24/8/2023, this court granted the interim anticipatory bail to the petitioner, namely, who is the petitioner?
Gyati Kago.
Mr. Namely Gyati Kago, in connection with Itanagar PS case number, Itanagar Women PS case number 79/2023. And it is submitted that the petitioner has appeared before the investigating officer of the said case and has cooperated with the investigation. Stop. Learned additional public, Mr. T. Ete,
Yes, sir.
learned additional public prosecutor has submitted that, has produced the case diary of Itanagar Women PS case number 79/2023, which was called for in connection with this case, and has submitted that the petitioner has appeared before the IO and his statement under section 161 CRPC has been recorded.
On 29/8/2023.
29/8/2023.
2023.
29/8/2023. As it appears, stop. Considering the submissions made by learned counsel for the parties as well as on perusal of the case diary, it appears that custodial detention of the present petitioner may not be necessary for fair completion of the instant case. Fair completion of the Itanagar PS case number 79/2023. Hence, the interim anticipatory bail granted to the petitioner Gayati Kago by order dated 24/8/2023, by this court is hereby made absolute. With the condition that he shall continue to cooperate with the investigating officer. Continue to cooperate in the investigation till completion of the investigation.
Investigation, yes, sir.
With the above observation, this instant bail application is disposed of.
All right.
18, who was the objector?
Yes, on the way, my lord.
He was just here only. He went to get the file.
Item number. Now, what is your apprehension? You suggest there are two submissions by the petitioners council that your FIR is, there are inherent contradictions in the FIR where you allege rape, but you also submit that you are living as wife of the petitioner. You stayed with him for a long period, for many years as wife. And then you are alleging rape. And then the second leg of submissions made by petitioners council is that this dispute arose only because of a land dispute where you wanted to have land and there was some dispute which led to filing of an FIR. And one more submission made that when you were residing together with the petitioner in a rented house, once some dispute occurred between you and the petitioner when you threw away the belongings of the petitioner and he was compelled to lodge an FIR. And that FIR was prior to lodging of this FIR. And thereafter only you took recourse to alleging 376 against the petitioner with whom you were staying as his wife. That is their submission. Now, without going into, because at the stage of bail, I will not discuss these things in the orders, which may make your case weak.
Regarding
Only requirement is whether his custodial detention is necessary, which learned public prosecutor says that the investigation is being conducted by a IO of a different police station, which is all women police station, and it cannot be influenced by the petitioner, though he is an inspector. We may give some additional protections if you want.
One thing, this FIR, the applicant, they are referring, this FIR was known before the police station where his police, in which he is the officer in charge. Nahalagan, that was Nahalagan.
That may be because of the jurisdiction.
My humble submission, this all, there was a misconduct on part of the victim. It is all the story now. Now I will come to the Malad, fact, Malad. Now what happened, Malad? Why I'm insisting Malad on this point, Malad? He had established relationship with the victim with deceitful manner, making him believe, making her believe that she's she's almost like married, Malad. It's acted in such a way.
But
Now-
they have also submitted what I have heard yesterday, that you also met his wife. And his wife also consented that you can stay with, you can continue with this relationship.
Now,
And you continued with the relationship with the knowledge of his wife.
now,
That means you also know that she is a married person.
now, in that after now they, what happened, the moment this all one come to the matter, facts come to the notice matter. Now, what happened, Malad, is having already married Malad, when this fact come to know Malad, and now he started different way, Malad. What happened, the earlier that plot of land, Malad, it was purchased by the victim, Malad. It was said it was executed in her name. Now, when even the accused has the written as if he is the husband of the victim, Malad. This everything there, Malad. Now that document has been stolen by the accused. Now they have prepared on this this all we have and even FIR also. Now thereafter, what happened, after exploiting the entire the victim life, now the all property that is owned by the victim, that has also been taken away. This is why thereby he started changing his color. Now you see the land sale in Malad, you see, I just marked page 8 of my plan.
You have filed a written objection, no?
Malad, this is the make mark one Malad.
What
Page
is
8 Malad. This certificate it was executed on 18 July 2022. Malad, it is the name of the victim, Malad.
No, okay, that you have already mentioned in your FIR. That your name was there, later on he manipulated it. That allegation is there, but it is to be investigated by the
Now, how he, the deceitful manner, how he induced the victim. Now, see, this is after getting this document, stored away the document. Now he started changing his color, rather avoiding the petitioner and threatening every time from somebody, if not directly, and from somebody else. Even on 29 August, when he was called, she was called there, Hotel.
Yes, Mr. Sherry.
Now, page 25.
One thing. The objector is apprehending that there may not be a fair investigation. If the petitioner is granted anticipated, unless he is detained, yes, there may not be a fair investigation. What is
Well,
this?
I'm exclusively on law, my lord. Look, since the FIR is very apparent,
Yes,
that is where I am stuck still, my lord. My lord, the
The
submission
purpose-
which has been made by the complainant, my lord, there's
Your-
nothing in the
Mr.
report.
Tabum. TABUM.
TAGUM.
Tagum. Mr. Tagum, this merely on perusal of the FIR, it appears that you incorporated 376 only to make your case stronger. The real dispute is
All fairness, my lord,
property dispute.
it reveals that they have been living together since
So I will
2016.
not make such observation in my order. But what protection you want so that fair investigation goes on? There is a dispute. Property dispute is there. Your 376 allegation may also be included into by the IO. Because you have filed an FIR and same has been registered. But it does not appear to be a case where the custodial detention is necessary merely because the accused is an inspector. That is my observation.
My first question, that's the principle of the bail. the principal govern the bail. That is, the bail is ruled and there is judgment. Now, that is in case of ordinary bail. Now, there's 438 bail and other regular bail is the distinguished matter. Now, 438 is a discretionary matter. Now, that prospect matter.
He is a service holder.
This principal matter, it cannot be relied. Those settled principle in case of regular bail, that principle is not applicable in the case of the anticipatory bail. Thus, I rely matter. Six, 7, 8, and 9.
This is item number.
Page class 7. Here, I was approach the issue and though it was considering the prayer for granting regular bail after that. The non-single judge of the High Court reminded himself of the principle that it is settled that bail and not the bail is the normal rule. And then observed that was not wrongly applied. There are 8. The above observations are more damaged while considering the application for home arrest bail. The consideration to waive that hold while dealing with the request for stay bail need not be the same as for application to release on the bail after arrest. At any rate, the non-single judge or not to have state the apprehension as straight by CBI. That also had one which can be made against all accused in all cases. The apprehension of fact reasonable when considering the high position which the respondent have in the nature of accusation relating to either. After destroying non-access places, including Perusa case that we definitely see that High Court has misdirected itself in examining discretionary power under 438 of the court by granting pre-arrest bail to the respondent. Therefore, my humble submission, all the matter of general principle may not be applied in case of considering statutory bail. And in the recent case manner, the Honorable Apex Court has also held that the only on the ground that the custodial information may not be required, that would not be ground for granting and executed. And mark the paragraph number.
Where?
I read it, madam. And that's mark, plain mark. on there.
This is a POXO case. no?
Yes, this is a first matter. Now regarding only on principle that custodial information, only on ground that it is not required. That cannot be ground for granting. I'm just reading.
Yes, there are other considerations also.
Yes.
I have never mentioned that there is no list.
That is, there are other considerations also. But in your case, it is not only not necessity of custodial intervention, but the tone and tenor of your FIR also.
Now the original document, my salary, that has been stolen by the accused manner. That has been I have reflected in the FIR also, even the audio record of the original order matter. Who default that, yes, original order now, he deceitfully came later on with prepared ready-made document record signed. This is how the deceitful conduct of the accused man. If really he has a bona fide matter, why he has not consulted, why he has not taken consent? This is the how the deceitful conduct on part, whereby he induced the victim to have a relationship, and victim being bona fide, being innocent, he fallen prey of this, the tricks of the accused manner. And later on, after taking away this old property, now she has sold this color matter. This is how this poor lady, harmless lady, has been treated by the alleged accused man. And for taking advantage, abusing his power of position, being the police officer.
Who is the investigating officer?
It's Nich Rupa, lady inspector,
Of rank of,
inspector,
and the accused is also of rank of.
inspector. But he's, the jurisdiction is different, man. One is at Itanagar and the other one is at Naharlagan.
Can it be investigated by a higher rank officer?
Can be done. Can be. Though there's no specific notification as such, but it can be done if there's a direction. But
My lord, will see. This is, I think we'll be filing shortly this event cost. This is not the case to be registered even. But plenty of judgments are there, my lord. These such cases are not entertained. Where the apex code also straightly says, my lord, once you have been staying together, relation doesn't work out, you cannot come with the allegation of rape, my lord.
Say, madam, let me complain. So far regarding madam, the belated filing FIR and this concern, madam. Now I appreciate, madam, that breach of promise and false promise. Now the manner in which the conduct of the accused, madam, it shows that fraudulent conduct is not a mere breach of promise, madam. It is false promise, it is fraudulent and deceitful conduct. How he has acted. This is what, madam, that is apart from that breach of marriage. I aware manners and breach of marriage, a breach of promise is a different thing. But it's the case of false promise, the fraudulent conduct on part of the alleged accused, taking advantage, abusing the power of being police officer, harassing the innocent, helpless woman, pressing him as and when he required, and losing FIR on his own, on the basis of generated story as you will feel like manners. But even young, helpless women would not have courage even to stand against the police officer. This is not
How long you are staying with the petition? You stayed with the petitioner?
Madam, it's since 2016. That's right. 7 years.
For last,
Now, there initially, but there it was made bona fide that he is unmarried. Now, on that, only on that fraudulent deceitful conduct on part of the alleged accused, madam, the victim happened to fall in his prey and relationship, the established relationship. And later on, he came to know that, no, he is already unmarried and he has been cheated, madam. Since this matter falls from there because of this fraudulent conduct.
no, these are allegations which are to be looked into by the IO during investigation.
Madam, that is why, madam, the fair investigation is required. Now, he being the IO, but it is easily reached with one, but now you see the FIR itself, madam.
Mr. Tabu,
FIR was madam.
Mr. Tabu, then it would mean that any FIR against police officer is lodged, then every time police officer has to be detained.
And
I'm not saying. FIR, I will see the manner in this FIR, this case has been revolving around. Now, FIR 18 August 2020, it was received, it was marked to IO. One S Naram. Now, how come he has obtained this number, the copy which is marked to IO has been obtained by accused? That is no, that is not, it shows the nexus. And accused with access to the police officer, IO, at any time whenever you feel like. And manner in which this adjustment mail was moved before registration. And that too.
That will only lead to an assumption.
Madam, my humble submission is the madam, fair investigation is required. And he being the police officer, including like anything, even treating the victim, madam.
Lord, I have a very strong objection repeatedly. He is casting aspersion on me. My lord, though I am a police officer, as before this court, my lord, I am just a citizen of my lord. The Constitution of India, the liberty which Article 21 gives, my lord, it doesn't say, my lord, that whoever, my lord, approaches before my lord say, It's not come with any rank or status. My lord. Here I am, my lord. My lord, if I have been so influential, my lord, why should I approach my lord? Why should I approach for my liberty? My lord, he can make any statement. I can make more than that, my lord. But that is not the issue. Who is speaking more? The grievance issue is only, my lord, has seen the FIR, my lord. My lord, the law of bail, my lord. My lord, I am not saying about other part even, my lord. The factors, relevant factors. My lord, the prima facie case itself, my lord. Yesterday I have placed, my lord, 2 judgments, my lord. I have one more judgment where the Supreme Court has said, my lord, completely, my lord, quash at all. I'm not talking about bail at all. No investigation at all. And I think only because of subsequent Lalita Kumari judgment, only such cases are to be registered. But not necessary, my lord. When case is registered itself, there is. My lord has seen, my lord has examined the matter, my lord. My lord, here only repeatedly casting police officer. I'm not here in the capacity of police officer. I am having the serious apprehension, the way, my lord, in which only because relation could not run, because tomorrow otherwise, my lord, no one's liberty will be safe. My lord. What will happen, my lord? Today itself, my lord, so many people may be maintaining relations, my lord. Relationship, their acrimony can come with any reason, my lord, any silly reason. And my lord, staying with someone for 5, 6 years, 7 years, and now is saying, you did not mean. Now, because, and my lord, and all this happened because of her own conduct only. And my lord, kindly, my lord, that matter will be clear, my lord. I will just show the, my lord, WhatsApp chat, my lord. The intention, my lord. Kindly, my lord, turn to page number 21. My lord. Page number 21, my lord. From the mediator, this WhatsApp chat, my lord, is saying here, my lord, that secondly, गोई को one written agreement होना ही है कि in future आपको भी ये property को claim नहीं करेगा बोल के. Please reply. I will pass your reply to Goi's family. Court case या local case करने से दुनिया मालूम हो जाता है, इसलिए ये decision लिया गया है. But they saying all the time they are behind this land only, my lord. And land, my lord, it's from my hard-earned income I have purchased, my lord.
No. That dispute may be there.
My lord,
not going into.
We'll go to the civil court. Remedy is there.
You pursue your remedies.
Yes, my lord.
Yes. Here the question is whether you are to be detained or not.
My lord.
That is the only question.
My lord. Prima facie case is there.
And I am convinced at this stage.
My lord.
That at this stage detention is not necessary.
My
If he cooperates,
my lord.
I will impose conditions.
My lord.
That during this period, under prohibition, under that, because of the deceitful conduct, now what happened? The victim sustained serious health injury because of miscarriage, because of medicine administered by the accused minor. That is all maladies.
These are the allegations which you have leveled in the FIR.
Yes, ma'am. Now it is my.
That is to be investigated.
Yes, ma'am.
If it is found true, trial will first follow. And if in trial, if he is found guilty, he will be punished. But merely by filing an FIR, you want him to be punished at this.
The liberty of a person, my lord, it's a very high pedestal in constitution. It's not, my lord, that
fair investigation. PP is ensuring fair investigation.
Yes, ma'am. That is why, my lord.
Because
in fact, my lord, they have to.
He is neither for you nor for the.
Yes, ma'am. In fact, for bringing a CD prior to 2 days, my lord, a PP should have been appreciated, my lord.
Yes.
Apart from making an allegation, my lord.
Cast an apprehension, because that calling for case diary is a communication between the public prosecutor and the IO. If-
They have to make sure, my
But
lord,
if
either,
you make a submission, that would cast an apprehension on the public prosecutor himself.
No, I'm not making cast my lord. I asked-
No, but it would have an implication of casting an apprehension.
they have to make sure, my lord, whether they have an allegation against the IO or the PP, my lord, for bringing the CD 2 days prior to the hearing. They have to make sure about that.
Mr. Rajesh
My-
Khuna,
my-
learned counsel for the petitioner, also heard Mr. T. Sharing, J. Sharing, learned public prosecutor, as well as Mr. T. Tagum, learned counsel for the victim slash first informant. This application under section 438 of the Code of Criminal Procedure, number 1973, has been filed by the petitioner, Shri Govind Arangham, who is presently posted as
Naharlagan Police Station.
as Inspector of Police
Inspector
at
Naharlagun.
Naharlagun Police Station, apprehending his arrest in connection with the what is the police station case number? In connection with
Women's PS case number
Itanagar
Women PS case number 85 of 2023.
Women PS case number 85/2023 under section
376, 420, 506 IPC.
376 420 506 of the IPC. The acquisition in this case is that on 18/8/2023, the victim of the case, within bracket real name not disclosed, bracket closed, had lodged an FIR before the officer in charge of Women Police Station, Itanagar, inter alia, alleging that he had that the present petitioner had committed rape on her by adopting fraudulent misrepresentation of promise of marriage. And under such dishonest assurance by the present petitioner representing himself as single, they established physical relationship between them. And between them stopped. Though it is also stated in the FIR that though the family members of the first informant slash victim initially opposed the relationship, however, gradually the said relationship was accepted, and the informant as well as present petitioner started living together for years. It is also stated in the FIR that later on the informant came to know that the present petitioner is a married man, and the informant also met the wife of the present petitioner, who did not had any objection, who also raised no objection in continuation of the relationship between the first informant as well as the present petitioner. It is further stated in the FIR that the where is the statement that she lived as wife? There is a statement husband and wife. It is further stated in the FIR that
My lord will see, one, two, second paragraph, last line. I
Page.
accepted to continue our relationship as couple.
page,
My lord, page 14, FIR, my lord. Page 14, second paragraph, last line, my lord. I accepted to continue our relationship as couple. And thereafter, my lord, page number 15 also, the entire paragraph he has mentioned. my lord.
That is in 161 statement, my lord,
okay.
in the case diary. Page number 9 of the case diary.
I accepted to continue our relationship as couple.
It is also stated in the FIR that the first informant continued the relationship with the present petitioner and stayed with him as couple. Some more allegations are leveled against the present petitioner in the FIR, including where is the allegation of miscarriage?
Miscarriage, the third paragraph. The fourth page for. All this year, well, I believe myself to be lawful wife.
It is also alleged in the FIR that during the relationship with the present petitioner, the informant conceived for the 3 times, but the present petitioner manipulated the informant to get her pregnancy aborted on all those 3 times. There is also allegation that in the FIR that the informant had purchased a land at Lekki. Lekki is a place at Lekki. However, the present petitioner by manipulation has taken away the sale deed of the said land from the informant and has manipulated his name in the said sale deed. So on receipt of the FIR, the Itanagar Women PS case number 85/2023 was registered. Learned counsel for the petitioner has submitted that the petitioner was having a consensual relationship with the victim and they stayed together as couple with the consent of his first wife, and some discord arose between both the petitioner and the first informant, which also resulted into lodging of an FIR by the present petitioner against the first informant on which when you lost the affair?
16/7/2023.
On 16/7/2023. That is much prior to lodging of the instant FIR by the present petitioner. It is also submitted by the counsel for the petitioner that later on a dispute regarding to land at Lekhi arose between the parties, and it is only because of the dispute pertaining to the property the present FIR has been lodged by the victim falsely against the present petitioner. Learned counsel for the petitioner has also submitted that though the present petitioner is an inspector of police, he would cooperate in the investigation, and the present, he would cooperate in the investigation, and hence praise for allowing him to go on anticipatory bail. So on the other hand, learned Mr. T. Sharing, learned additional public prosecutor, has produced the case diary of Women PS case number 85/2023, which was called for in connection with this case, and has submitted that in the meanwhile, the investigating officer of this case, who is also of a rank of inspector of police, has recorded the statement of witnesses, including the statement of the victim.
Only one statement.
Statement of the
Of the
victim.
victim.
Statement of the victim under section 161 of the Code of Criminal Procedure, wherein the victim has stated that he stayed with the present petitioner as his wife.
Husband and wife.
She stayed with the present petitioner as husband and wife
Wife since 2008.
since 2018. Stop. Learn.
Page number, may I take my note to page number 2 of the case diary?
Case number
2. Case diary.
page. No. On the other hand, Mr. G. Tagun, learned counsel appearing for the victim, has vehemently opposed grant of any favorable order under section 438 CRPC to the present petitioner on the ground that the present petitioner is holding an influential post in police, that too of an inspector in Naharlogun police station. And there is every possibility of his interfering with the investigation. It is also submitted that he has been interfering in the investigation even before registration of the case by the case on the basis of the FIR which was lodged by the present petitioner. It is also submitted that after filing of the FIR, the present petitioner also sent 5 unknown persons to the first informant to convince her to withdraw the FIR. I have considered the submissions made by learned counsel for the parties in this case. I have also. Yeah. I have also considered the materials available on record, including the case diary of women PS case number 85/23. Though at the stage of grant or rejection of or an application for anticipatory bail, it is always advisable for the court to avoid detailed discussion of the materials on record, as it may have an effect on the rights of the party during trial. However, considering the tone and tenor of the content of the FIR, as well as facts and circumstances of this case, also considering the fact that the investigation of this case is being conducted by an officer of the rank of inspector, who is not below the rank which is held by the present accused, present petitioner, this court is of considered opinion that if the petitioner cooperates with the investigating officer in the fair completion of the investigation of this case, his custodial detention may not be necessary. In view of above discussion and in view of the submissions made by learned counsel for the petitioner, as well as learned additional as well as by learned public prosecutor, the petitioner, Mr. Govind Arangam, is hereby directed to appear before the which SP you have approached?
Itanagar SP.
Who is the controlling officer of the
Women.
and
Itanagar SP.
under which SP the women police station is there?
Capital Complex, ICR,
Different SP is there.
or Itanagar Capital Complex. SP.
No, this WPS,
Yes,
women PS case number is pending in the court, in the which police station? Women police station.
Itanagar Women Police Station,
And who is the controlling SP? Itanagar.
Itanagar.
What was the last line? Appear before the investigating officer of the women PS case number 85/23 within a period of 7 days from the date of this order and cooperate with the investigating officer. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with women PS case number 85/2023, he shall be allowed to go on bail of rupees 30,000 with one surety of like amount to the satisfaction of the arresting authority, subject to following conditions. What condition you want? That he shall not directly or indirectly make any inducement, threat, or promise to the victim or to any other person who is acquainted with the facts of this case, so as to dissuade him or her from disclosing such facts before the investigating officer of Women PS case Itanagar Women PS case number 85/2023. Stop. Number 2. He shall appear before the investigating officer of Women PS case number 85/2023 as and when so required by the investigating officer of the said case. Who is the senior officer? The lady,
He's the inspector, man.
both are inspectors.
Yes, ma'am.
If he says that I am senior to you,
That I have to ascertain.
irrespective of their inter se seniority. Stop. It is also directed that the superintendent of police of Itanagar district is
Papumpari, Capital Complex.
Itanagar Capital Complex shall personally monitor the investigation of WPS case number 85/2023. With above observation, this instant anticipatory bail application is disposed of. Let the case diary be sent back. Yes.
Well, one thing about this, as and when required, I need to appear. Some limited time may be given during the period of investigation, 90
No,
days.
as and when,
Otherwise,
as and when required during the pendency of the investigation of WPS case number 85, only during investigation.
My lord,
After investigation is over.
but investigation, my lord, it's 90 days statutory period. So if they cannot complete it within, so if they say that entire period during the pendency, so that may be something difficult for me also. So that, but
No,
within
you
90 days.
cooperate, otherwise you are a free man.
My lord, right. Well,
Otherwise-
90 days, because statutory period is 90 days, my lord.
It's already there, and I.
Within this 90 days, my lord, basically.
Investigation.
Let it be there.
Right.
Otherwise, Mr. Tadum will not,
Being a police officer. Deeply obliged, my lord.
because even after 90 days is only for detention. But the cooperation may continue even beyond it.
Yes.
This is a leg of cooperation.
I am.
With above observation, this anticipatory bail application is disposed of.
Much obliged.
Wait, Mr. Lords. This is a regular bail application. I'm seeking your lordship's indulgence only on health grounds now. Earlier, my lord, the bail petitions were rejected by this honorable court also. There is no new ground, but on medical grounds. my lord. A few dates, my lord, I'll just point out.
What
The-
is, what is the allegation?
Allegation, my lord, was in respect of, my lord, that the accused person has paid money to obtain question papers for his daughter for his
Paid
selection,
money for?
obtaining question papers, my lord, in respect of the selection process conducted by the Arunachal Pradesh Public Service Commission.
You are the bribe
Father.
giver.
No, the prime accused is,
Allegation is the
allegation is against one of the deputy.
Obtained
deputy
money.
secretary. No, paid money
paid money to
to
whom?
the deputy secretary. Come, deputy controller of examination.
He is also an accused,
Yes, he would be the main accused because he is the person who had access to the,
accepted.
I am a beneficiary, so that is the allegation,
But you are also an accomplice.
my lord.
Accomplice.
Oh, I would not
You
say
are the main
accomplice, the
accused.
allegation is that, my lord, there are allegations against many people, around more than 40. That these are the persons who obtain by paying money to this deputy controller of examination, that they obtain the question papers for their children's wards, like that. I'm not on that, but I'm only on the medical ground, if your lordship, I will show the document and lordship may consider whether. it's a
When
case
were
for-
you arrested?
I was arrested on 30/09/2022.
Okay, it's long period.
Yes.
How many days?
Now, it's almost a year now, my lord.
Exact days.
I exactly, I will just, 365 minus 39 very strong. It should be 330
Okay.
days something.
It is Charge sheeted case.
Charge sheeted case. Charge sheet was submitted on 8/12/2022.
What is the stage of investigation?
That's what I wanted.
Stage of the trial.
It was consideration of charges was fixed on 6 occasions. Not yet, my lord, friend. The first date was 3/3/2023, my lord. Would not be taken up.
Who are the other co-accused persons with you? How many co-accused are there?
In this case,
When it was
7 men,
7,
8 men.
all 8 are under in custody.
No, my lord, only the deputy controller and one Tamasaro is under custody. All are on bail.
What were the allegation against those persons who are already released on bail?
But they are all beneficiaries, my lord. In fact,
They are placed like
Bail-
you.
yes, allegation was that I bought question papers for my daughter. Even she has been released on bail. She was also under custody.
Okay. Your daughter has been released on bail. Okay. And charges are yet to be framed.
Yes,
What is your ailment?
my lord, if your lordship may kindly come, I had in fact, an accident.
No, before that, when it was rejected on the prior occasion, by this court, it was rejected.
Yes. I'll just point out, my lord.
By which court?
First, by the trial court on 18/10/2022.
At page?
That order is not here, my lord.
Okay, the rejection order of this court.
This court is, my lord, page 28. That was on merits. Page 28.
But this, it was rejected by Justice Tagia,
Yes.
who is available.
Oh, man, that's why I'm not on merits, my lord. I will just confining myself. I'm seeking lordship indulgence
No,
on,
no.
my lord, change
The
circumstance.
question is, there is a notification by High Court
Yeah.
that if a bail is rejected by a bench of court of this High Court, normally it should go to the same judge. That is not applicable here in Itanagar bench.
I'm not aware of that, but my lord, I'm not pressing on merits, my lord. I'm just,
No. Before that, would it be appropriate for me to consider or to send just to consider because of that there is a notification?
I'm sorry, my lord, I'm not aware.
My lord, in our bench, in fact, we are not,
Anybody can take.
we are not following, my lord, as we seen in the, my lord, the several occasions.
No, if the concerned judge is not available, who rejected the
Yes, ma'am.
earlier bail.
Otherwise, my lord, the practice here is court number 2 is taking up the bail matters.
No, okay. But suppose because of the said notification, if there is a rejection, it should go to the same judge by whom the bail was rejected on earlier occasion. And only if that judge is not available in the bench, then it may be taken up by the regular bench.
But if there
Court
is
number 2 is the regular bench. But otherwise it was, and also on the ground that if the earlier judge recuses on the second time, it may come up before. Because I am aware about that notification.
in that case, my lord, may, relying on the notification, place it before the honorable justice.
Who can place that notification?
I'm sorry, my lord.
We are also unaware of that notification, ma'am. Basically, my lord, as per the professor is pointed out by the counsel for the petitioner.
Prosecution
Prosecution,
team, any of the public prosecutor, there is a notification.
From the High Court bar, I'm not aware, but your lordship, there is a judgment from the Supreme Court also regarding this, that if the same judge is sitting, then it should be placed before the same judge, that's clear.
No, yes, there is a notification. I am aware of that. From.
Maybe the registry will know, my lord. Registry will know, man.
So let it come up before Justice Tagore. He is available here.
Man.
And if he says that, no, it may be taken up by the regular bench, only then it will have to come. But without his
Man.
notice, it should not, because of that notification.
Man.
Heard Mr.
D. Pangin.
D. Panging. Oh, you are Mr. Dicky Panging.
Man.
I heard your name several times today.
I hope nothing bad, my lord.
Learned counsel for the petitioner also heard Mr. M. Kato, learned standing counsel CBI.
Right.
As it appears from record that this instant application is moved by the petitioner for the second time seeking bail after his previous bail application was rejected by a coordinate bench of this court within bracket by Honorable Mr. Justice Nani Tagore. Command. As this, and as there is a notification to the effect that in the event and previous bail, is it there? And as per notification dated 20 August 2021, if the judge who rejected the previous bail application is available, the subsequent bail application shall have to be listed before the same judge. Thank you. Same judge. In view of above, the registry is directed to list this bail application before appropriate bench.
Man. Okay. Leave table.
You may call an item or call Jamadar. You have two options. After lunch. Yes.
I, on behalf of the petitioner,
Microphone.
against the impugned judgment passed by the Honorable Civil Judge in the Division, Westchang Alo, on the date 27 July 2023. Annexure 1. Your Lordship, that the petitioner applicant is residing at the same place and the brother-in-law to each other. In the year 2016, the petitioner take a loan of rupees 10 lakhs from the respondent. But on the same date, the respondent along with one witness come to the house of petitioner and force him to sign one blank.
We will issue notice.
Yes, yes.
Heard. Mr.
This Sora, Domin Sora,
This is item number 20.
17.
D. Sora, learned counsel for the appellant. This appeal has been preferred by the appellant Lizum Ete under section 96 read with order 41 of the Code of Civil Procedure, 1908. impugning the judgment and decree passed by the Court of London Civil Justice Senior Division West Sian, Alo, on 27 July 2023 in money suit number 4/2021, whereby the suit of the you were the plaintiff
Yes, Your Worship.
in the trial court, you were the plaintiff.
No, trial court, I'm respondent.
What is your name?
Liju Mate.
Liju Mitte.
Yes.
But you have mentioned here appellant / plaintiff.
Actually, in that money suit, I am respondent. Here, but I am petitioner.
Here you are appellant.
Yes,
But
appellant.
You have mentioned appellant / plaintiff. It should be appellant / respondent. You are not plaintiff.
In this case, I am plaintiff. Appeal.
So how in appeal you can be plaintiff? In appeal, you have to be either appellant or respondent.
Yes, Your Honor.
The role does not change in appeal. In the trial court, you were the defendant.
Yes.
The suit was decreed against you.
Yes.
You have preferred an appeal against the decree
Yes.
as an appellant.
Yes.
Then you have to mention here appellant / defendant, or only appellant would suffice.
Oblige.
What was the last line?
421.
Suit of the plaintiff was partly decreed, directing the present appellant to pay. What was the decree? What was the direction? Directing the present appellant to pay an amount of rupees 32,51,836 along with pendente-like interest and the future interest at the rate of 6% per annum till the date of realization of the decretal amount to the respondent / plaintiff. Issue notice to the respondent. The appellant shall take steps for issuance of notice to the respondent by registered post with AD returnable after 4 weeks within 3 days from the date of this order.
Yes.
Let this matter be listed after.
Yes. I do oblige.
Yes, Lordship. This petition is for the setting aside in cause of the domestic violence pending before the Judicial Magistrate Ala Lordship. On the ground that Lordship, this petitioner and private.
NCR is there. NCR is there, no? Okay. You are ready?
No, my lord, I'm legal aid counsel for the respondent number 2. Recently I have received this petition copy and I will file a reply, my lord, in this case. And I
Let
need
her
some
file.
time.
Let her file the reply. Heard Mr. D. Loy,
G. Kato, Lordship.
G. Kato.
Yes, Lordship, last occasion, the opinion of this honorable court was that for the interim order, because interim order, that if respondent party, private parties is present, then interim will be given. This was the opinion of this honorable
But
court.
she let her go through the record. She is a legal aid counsel.
Yes, I'm legal aid counsel.
She has to prepare. We
Yes.
will fix a short date.
Yeah, Lordship, the meantime that interim will be because case, once case is decided, that it will become infectious, lordship. So,
What is the,
domestic violence, lordship. Lordship, my contention is now the
at what stage it is there?
lordship adverse is that at the same time there is a maintenance, interim maintenance, lordship.
Maintenance is there. You
Yes.
are paying, pay the maintenance.
Yes, lordship.
You are
That-
paying the maintenance.
Yes, lordship. That
You are
as per-
against that maintenance order.
yes, lordship, there is, I have annexed, lordship.
What interim relief you are seeking?
That lordship, interim is to stay this domestic violence case number, lordship.
Only domestic violence.
Yes, yes, lordship.
Not the maintenance.
Lordship, also this comes up with the maintenance also, lordship.
No, but maintenance.
Maintenance, lordship, maintenance, this is same case, lordship, maintenance, this is. Under
So if-
domestic violence,
If we give stay, the maintenance will also get stayed automatically.
yes, lordship.
Then we have to hear her, let her prepare.
My
You
lord,
prepare yours.
maintenance, Your Honor, in domestic violence case, the monetary relief is given, Your Honor.
How much?
And 3,000.
You are seeking stay of that.
yes, lordship.
Then we have to hear. You continue to pay for one more month. It will be,
3,500 only.
it is a small amount.
Yes, my
Right.
lord. And this monetary relief is, Your Honor, given, they have agreed to pay, Your Honor. There was one local meeting was there, Kebang was there. And in that Kebang, this respondent agreed to pay the maintenance amount.
Exactly, lordship. This is my, those, lordship, in Kevang also, there is maintenance. And even
In
as per the
his documents, Your Honor, only I am submitting on basis of his documents only.
lordship, this is the reason that stay for the interim stay for the division domestic violence is required, lordship. And if this is not admitted, this case is not admitted, then domestic violence can be then restarted, lordship, just for the interim, lordship. Stay may be granted. Lordship, it was opinion of the dishonorable court as well.
Where is the opinion?
Lordship, that in Barbelli last time, that this honorable, that in case of this opposite party, FER, lordship.
No, but let her prepare.
Yes,
lordship.
yes.
She is seeking time.
Lordship, she's
We will fix, she is a legal aid counsel defending the others.
opposite party.
Woman,
Yes,
No,
yes, my lord.
A woman is opposite party, lordship.
she is defending her.
Yes.
Yes, lordship.
Let her prepare. We will give a short date. How much time you require?
My lord, cases, domestic violence case is pending before Learned CJM Aloe. That matter is fixed on, I think, 12th of this month for final argument.
For
This-
final argument.
Yes, lordship. This is the reason, lordship, that is the once. this
And
final-
my client is now residing at Aloe, my lord, so she need, I have not instruction, Your Honor. Proper instruction. I have to get proper instruction.
The case can be restarted after this this instant petition, lordship.
And my lord, can you see the page number 24 of his petition? In last line itself, it is page number 24 is a translated copy of Kebang decision. In last line, it is
You-
agreed.
What you want, the stay of, it is in the, for final argument. What have you challenged in this?
Now, lordship, domestic violence is only applied to the same family, lordship. Once this marriage is dissolved, that it cannot be applicable.
What is the interim monetary relief granted to the,
Only 3,500.
you continue the interim monetary to pay the interim
Lordship,
relief. We will stay the proceeding of domestic. violence.
lordship, once this proceeding is, once the proceeding is stay, then this interim also,
Now, Mr.
and lordship, this
Tado, you are also appearing. Now, you want the
stay of this proceeding. lordship.
proceeding,
Yes, lordship.
and what will happen to the interim?
Interim lordship, that once this proceeding is there, then automatically this is offshot case, lordship, interim is. And interim also will be,
Automatically.
yes, lordship.
That I am not inclined to. you are challenging the pendency of the proceeding on what ground?
Lordship, that opposite party, once he happened to be my wife, now is not the wife, Lordship. And only domestic violence applicable for the when there is a domestic relation among the family. Now opposite party is not my family, Lordship. There is maybe case in CRPC and some other, but domestic violence is not applicable now, Lordship. This is my ground.
That we will consider. Let her file the
Yes, I will.
objection. Let her file the objection. Why have you approached so late? with
Lordship,
the-
Yes, Lordship, in fact, we have to connect some documents from the concerned local authority, I mean, head Gambura of the village, Lordship. That only the head Gambura, that only throw them, that at least we can come up with the documents, Lordship. Lordship, page number 25 is clearly written that opposite party is now wife of the some third party, which means that lady is not in position of my wife, Lordship. And when there is only this dispute between the family, then domestic violence applies, Lordship. Domestic violence is not for that party that belongs to.
Yes,
belongs to.
Mr. Tado, will you say something?
Yes.
Are you prepared?
Domestic violence, your lordship. There may be order that the act should not be repeat. The violence act should not be repeat. In the form of the order that
No, let me make one thing clear. This case is fixed for admission hearing today.
admission hearing.
The legal aid counsel says that she needs
She's
some
going to
time.
file reply.
She needs some time to file reply. On the other hand, counsel for the petitioner says that as the main case is pending for final argument in the Alo court,
Yes.
Alo court on 12th,
Yes.
unless it is, the proceeding is stayed, the main case may be disposed of, making his present petition infructuous.
Exactly, Lordship.
So, and otherwise I am not inclined to interfere in the monetary relief, interim monetary relief at this stage.
Exactly also.
Lordship,
Your
let them.
Lordship, if the main case is pending at the stage of final argument, so this court may restrain from self-restraint to interfere with the,
In a 482 petition.
yes,
Lordship, then monetary.
with the lower court proceeding.
No,
This-
but he says that it is beyond jurisdiction. The husband, that domestic relationship is not there. But that the trial court may also hold in the final judgment.
Yes, they may come in the
On
form of
appeal,
appeal or revision.
in appeal you may. appeal.
Yes, if it goes against him, if judgment goes against him in DB case.
Exactly that in which stage I don't know, that as argument is to be done is admitted. that-
Then let the legal aid counsel file a formal objection. We will fix it shortly.
And Lordship, as far that as I am informed by my client, only this evidence stage is going on. Evidence stage. Now after the evidence.
Yes, sir. In my lord, in that case, if matter is pending at the evidence stage before land trial court, then your honor, my lord, he counsel for the appellant submit that there is some, she is not his wife. There is some documents he adduced in this case. These documents can be adduced before learned trial court also. In evidence stage.
You appear, you
The
you
Lordship,
take this plea before the trial.
the Lordship,
You are taking the plea which can be proved in the trial.
Lordship, once this trial is started, in fact, I have verbally, I have informed that this honorable court of trial court, but still proceeding is going on, Lordship. That is where Lordship, at least to next hearing that interim stay may be Lordship given. And I'm not afraid for the stay of this interim Lordship, this maintenance, only for the proceeding of the main case. Lordship.
My lord, in any case, there is a provision for the alteration and modification of the interim order also.
You file objection.
If he,
No
if he
stand.
if he wants alteration and modification, and he don't want to pay the interim maintenance, he can Your Honor, approach before.
I have understood.
There is a
Let her
provision.
file the objection, no stay at this stage. We will fix it shortly.
Lordship,
Your Worship, petitioner here relies only on the basis of KEBA decision, the outcome.
These matters can be placed before
Yes,
the trial court.
to prove the veracity of these documents, it has to be determined
Yes.
by
Trial
Trial-
court only.
trial.
So proceeding may go on and let legal aid correspondent to be filed, allowed to be filed reply in this case.
Heard Mr. G. Kato.
Lordship, may I refer one?
Yes.
Lordship, this KEBA decision, local decision, wherein I have been asked to pay 1,20,000. This is another. And moreover, in domestic violence also, this means I have to pay for the same, in same case, I have to pay for the 2 times. Lordship.
No, but what I understand, in domestic violence, you have been directed to pay
Exactly.
3,000 something as interim maintenance. There you can take plea, it is going on. Regarding Kebang decision, you can go to appropriate forum wherever the appropriate forum is there, district judge or additional district judge. But in pending domestic violence case, you can still take a plea, but let us see what objection they file.
And moreover, Lordship, if stay is given, that right of this interim is not devoid, Lordship. After the completion of this case also, this case can be restarted, Lordship. On that ground, opposite party is not devoid of the hard right.
No,
Lordship.
for interim for grant of interim, you must have a very strong case, which otherwise you would be jeopardized. But you can take all pleas before the trial court.
Lordship,
So
that-
at this stage, no interim.
Lordship, after the
Protection order.
By the Okay, heard Mr. G. Kato, learned counsel for the petitioner. Also heard Mr. G. Kato, learned additional public prosecutor, as well as, what is the name? J. Doji, learned legal aid counsel defending the cause of respondent number. Respondent number 2, learned legal, Mr. J. Doji, learned legal aid counsel has prayed for some more time for filing written objection.
Lordship, after 1 week, Lordship.
Let consent. How much time you require? Considering the submissions made by the London Legal Aid Council, her prayer for some time for enabling her to file written objection is allowed. Let this matter be listed after 2 weeks. In the meanwhile, London Legal Aid Council may file her written objection as stated.
May I please, my lord? My lord, this is the joint petition filed by the informant and alleged accused person under 482 of CRPC in connection with Sagali Police Station case number 10, 2023, under section 363, 365, 341, 342, 506.
363 is kidnapping.
Yes, 365, My lord, this case has already been settled by amicable settled by both the parties with the intervention of Gangbura, well-wishers, and elders, because labeled in the FIR, level against the allegation level against the alleged accused persons in the FIR is false and concocted. There was no any act of kidnapping or abducting was done by the alleged accused persons. So based on that, considering that they have settled the matter amicably. So my lord, by humble prayer,
Where is the observation that there was no
my lord,
act
is
of?
amicable page number 25. It's annexure 4.
But at what stage the case is, charge sheet has been laid?
No, this is the FIR.
FIR stage?
Yes.
Page number?
FIR. Yes.
No, that no act of kidnapping has been done. The settlement deed.
In this case, my lord, the police issues 141 CRPC and the accused is already appeared before the police stations, and the IO of the case is already recorded.
No. That there was no, what was the settlement? Where is the settlement?
Settlement is page number 25. And annexure for page number 25.
25.
25 and 26.
25.
Yes, 25 and 26 page numbers.
Last page number is there, 24.
No, 26.
The deed of agreement, it is 23, 24.
23, 20. Married, my lord.
Yes.
This compromise deed of agreement
The
is
last matter.
this compromise deed of agreement is made on 24 June 2023 between Sri Navam Tama, son of Sri Navam Tagan, as about 22 years, a permanent resident of Lech, Rugo, P.O. Mingyo and P.S. Sagali district, Papumpara, Arunachal Pradesh, hereinafter referred to as Pars Party, and Sri Navam Tadung, son of Sri Navam Tai, age about 26 years, a permanent resident of Lech, Pilatri.
Who is the accused?
Accused is Mr. Navam Tadung.
Navam Tadung.
Yes, second party.
And who was kidnapped?
Your Honor, actually, there is no any kidnapping or abduction is done by the alleged accused persons.
Yes, read. Whereas the first party.
Whereas the first party had carried timber from Silsango jurisdictions to capital regions, Itanagar, without intimation permissions to all Silsango youth associations, which is clear violation of provision of Article 18B of Bylaw Book of the All Silsango Youth Associations, wherein the transportation of timber is prohibited without the jurisdiction of Silsango circles. On 8/4/2023, the second party was saw, that means Navam Tadung, alleged accused person, saw the Tata Mobile carrying timber from Silsango jurisdiction to capital region Itanagar. Well, saying that the second party was stopped Tata Mobile driver on the road and made a query about the transportation permission granted by all Silsango Youth Association. A second party is also committee member of the said associations. My lord, this is the second party is the core committee member of the all Silsango Youth Associations. After query about that, both the parties were dispersed from the spot where said vehicle was stopped. On 11/4/2023, zero FIR was filed against second party by the first party at Naharlagan Police Station, and same was forwarded to Sagali Police Station, which is registered as Sagali PS case number so and so. Regarding a pursuit violation of provision under Article 18B of Silsango Youth Associations, meeting was held at G Extensions, Naharlagan, 24th day of June 2023, in which the first party was admitted his mistake. So here is first party admitted his mistake. That means informant. Seek his mistake and seek for pardons. Seek for pardon. Eventually, both the parties have settled the aforesaid dispute amicably under the following terms and conditions. One, that the first party regretted his transportation of timber and voluntarily apologized not to repeat the same in near future. Whenever required to transport the timber for personal use, seek duly permission from all Silsango Youth Associations. Second, that the first party shall withdraw the zero FIR dated 11/4/2023 at Naharlagan Police Station, in which said FIR has been forwarded to Sagali Police Stations. And same has been registered as Sagali PS case number so and so. And third, that both the parties shall not repeat the said case in near future. So, and this was duly executed before the executive magistrate. So, my lord.
What was the FIR? What was the allegation?
FIR is annexure 3, page number 15 to 24. FIR. May I read the FIR? It is to complain against one Sri Navam Tadon, son of Sri Navam Tai of village Pilatri. It is informed that on 8/4/2023, FIR against one Sri Navam Tadon, son of Sri Navam Tai, village Pilatri. He kidnapped my Tata mobile driver who carrying timber from Rugo to Naharlagan for my personal use.
Whether case diary was called for? It has arrived. It has arrived. Okay. Yes. What was the allegation? Yes, read the FIR.
For my Tata mobile driver who carrying timber from Rugo to Naharlagan for my personal use, not for sale. I have taken written permission from my village Gangbura to take away only for personal use. During way to Naharlagan, I was driving my personal car and Tata mobile drivers were following me. When I noticed Tata mobile was not following me, then I tried to contact driver but not found any response. After that, I followed back for searching of driver. After hours of searching, I found that above said persons was stopped by driver and forced to sit their Maruti Alto car, forcefully kidnap my Tata mobile driver, Atikul Islam and MD Monas Ali for no reasons. And when I reached at place where they stayed while talking with kidnapper with peaceful manner, I requested him, but he ignored my word and not to letting us go. Meanwhile, he started hot argument with me, even after saying the permitted document. And also he warned me like, "Tum jaake dekho khud ko, itna se tumko hum kya karega dekho." In presence of my younger brother and driver, he openly life-threatening and dire consequences. If in future anything happen with me and my family members, they are sole responsible for that age they threaten me. Therefore, it is so. My lord, this is the FIR allegations. Actually, there was no any kidnapping or abduction was done by the alleged accused persons. So this FIR is purely a totally false and concocted. So my humble submission is this court may interfere and set aside the FIR dated.
What is there in the FIR? In the case where these two persons, what they have stated, Atikul Islam and Monas Ali. what they have stated. They have implicated or not. No, you need not to read out. You just tell me.
Yeah, their statement, Lordship, they have been carried by their car, Lordship, but as after some time, they dropped them and they
They were released.
yeah, they released. Yeah.
Whether
It's not
they
like
fled
that, they
the
are
state.
completely, it's not kidnapping, it's not like that, Lordship. They just carried them with them, so to inquire about from whose timber is there. And while he's there, this owner reached, they released him.
What is your
This much,
submission?
yes,
What is
and
your-
this accused statement also been recorded after when this.
So is it a fit case to be quashed?
Lordship, yes, Lordship, is because this Lordship investigation also been completed. As per the investigation, Lordship, there's nothing kidnapping as such been found out, Lordship. So it can be Lordship.
Okay, allowed, petition is allowed. I'll dictate the order in chamber. With reasons, I will dictate it.
Lordship and CD, I can.
CD I want. it.
Lordship,
I'll return it after dictation.
Lordship.
The prayer is allowed.
Obliged.
I'll use, go through the order later on. I'll dictate it in the chambers.
Obliged.
Obliged.
Must be.
Give it in my chamber. Any-
May I please, my lord? Lordship, this is a CRP with regards to the order passed by the learned civil judge senior division for civil imprisonment of Taba Tahi.
Oh, yes.
Yes.
Now the other side is there.
Lordship, no other side is not there, but I have,
You could serve the summons.
I have served. They are residing just nearby this railway station. I myself went with a copy of plaint with an order, but they have received, I have given an affidavit, they have received, but they have refused to put the signature. And they are stating that if the other judgment debtor, that is one Sri Tana Tahi, if he is not arrested, then they don't want the release of Taba Tahi. They said like that. And I have also informed their counsel in the present case.
But council is also not. appeared.
Not appeared. But I have served the copy of notice. I have taken affidavit. So my prayer is that Lordship, in this case, there is an instruction from the family member of judgment debtor.
Where is
that-
the affidavit? Whom you have given?
I have given to the decree holder. Tabatana. In presence of her daughter and wife at his residence, which is just 2 kilometers away from this honorable court premises. Yesterday at about 6 to 6:30 PM, I along with my associate counsel, Lordship, they have a knowledge regarding the case. Now my submission before this Lordship is that, Lordship, the family member itself, they said that they are ready to pay, but in order to take out the money, the judgment debtor who is inside the custody, he need to come out. So at least my prayer is that at least 1 week time also may be given so that the half of the decretal amount will be paid back within one week, half of the decretal amount.
And after paying that half, you have to go back inside the prison again.
If not complied, then so in
Not for the rest of the half.
no,
rest-
definitely that will be paid, but as of now, within one week, I am ready to pay half of the decretal amount.
But with half, the decree holder may not agree to.
Within 1 month, I'll clear, within 1 month, I'll clear, but within 1 week, I'll pay half of the decretal amount, which is in my account. For that, I need to come out, Lordship. I need to come out and I have to do withdraw because there is no any signed check in advance, which is in the hand of my family members. As I have already submitted yesterday also that I am the head of the family, account is being maintained by me only. So Lordship, at least 1 week time. I'll try to clear all the decretal amount.
No, you give an undertaking that you will pay the entire decretal amount.
Within 1 month, within 1 month, I'll give an undertaking.
Heard Mr.
Titaba.
Titaba, learned counsel for the petitioner. None appears for the respondent. Learned counsel for the petitioner has submitted that the petitioner has furnished an affidavit of service, affidavit to show that the notices issued to the respondent were served through dusty mode by the petitioner as per direction of this court, and the notices were received by the decree holder, that is the respondent Tabatana himself, in presence of his
Wife and daughter, major daughter, who is an LLB student,
wife and daughter, at around
6 to 6:30 PM.
6 to 6:30 PM on
On
5th of September 2023. Learned counsel for the petitioner submits that the petitioner has been detained in civil prison in pursuant to the order dated which order?
Yes.
Sending you to civil prison in pursuant to the order dated 26/8/2023 passed by the Court of Learned Civil Judge, Senior Division, Capital Complex, UPI, in execution case number 13/2022. It is also submitted that the outstanding decretal amount which is to be paid by the anything. What was the is also submitted by the learned counsel for the petitioner that the decretal amount which is to be paid by the present petitioner to the respondent within bracket decree holder is how much?
29 lakhs.
29 lakhs. Will
Yes.
you be able to pay within 1 month? Don't give an undertaking which you are unable to.
I am ready to pay half of the amount of 29 lakhs.
When
Will
will
it-
you pay full? Because unless you pay full, you will not be released. For half, you will be released for 1 week. Thereafter, you have to again go.
Was it 1 month? 1 month. 1 month, in a month.
Otherwise, you have to go back into prison.
Lots, I agree with that.
You'll be able to pay last. 29 lakhs, which the petitioner is ready to pay within a period of 1 month.
1 month.
He also submits that the petitioner is able to pay half of the decretal amount within a week from date of his release
Lordship.
or from the prison, as unless he is released from civil prison, he may not be able to withdraw the money which is available in his bank account. And hence, the petitioner, learned counsel for the petitioner submits that the petitioner may be released in interim to facilitate him in paying, in complying with the decree, at least to the extent of half of the decretal amount within 1 week from the date of
Lordship.
his release. You have to furnish bond.
Personal bond.
With sureties. The person is to be released from civil prison.
As of now.
Okay. The considering the submissions made by the learned counsel for the petitioner, in interim, the petitioner within bracket judgment debtor is required to be considering the submissions made by learned counsel for the petitioner, it appears that unless the petitioner is released for a short period of time to enable him to arrange for the money which he has to pay for honoring the decree, it may not be possible on his part to pay the decretal amount. Hence, the petitioner is released for 15 days.
30 days, Lordship.
For
1 month.
For a month.
Yes, Lordship.
In interim. Subject to furnishing of a bond.
PR bond.
With sureties. You will be able to arrange surety because the amount, not PR bond, with one surety.
Okay.
Subject to furnishing of surety of rupees, subject to furnishing of bond of rupees. How much?
I'm already a judgment debtor, Lordship. 20,000.
Subject to furnishing bond of rupees 20,000 with one surety of like amount to the satisfaction of the executing court, that is the court of learned chief judicial, that is the court of learned civil judge, senior division, capital complex of UPR. So as to enable him to the judgment debtor. Let this matter be listed again after 4 weeks. Should I give a fixed date?
No problem.
Fixed date after 4 weeks, after 1 year. Let this matter be fixed again on 3rd of October.
Okay.
3rd of October. Let a copy of this order be also furnished to the executing court, that is the Court of Learned Civil Justice Senior Division, Capital Complex at UBA.
Deeply obliged.